Group number one, let's get started with group one. I'm going to call out your names to confirm who is present, who is not present. Anyone who is absent, obviously, is not getting any marks for this assignment. What do I need to do? Okay. Group number one, I am waiting for you to start sharing your screen. There's no time to waste. There is no time. In fact, your time starts running now. Time is just so precious. There is none at all. Office clip. See stapler. Is it office clip tafadhali? Kila step now. Unmute yourself and ask me the question. Cosmas, unmute yourself and ask me questions. I want to hear your voices. Unmute yourself and ask me what question you have.
Hello, ma. Excuse me.
Cosmas, unmute yourself and ask me questions. So the first ICSA, I had Rebecca. Rebecca, you're in ICS. Who is in ICSA between Rebecca and Rosemaria?
I'm in ICSA.
Okay. So group number one,
Hello.
Daniel, please don't get overexcited over Cosmas questions. What group are you so that your group can present next?
Me.
Can we have now, what do I need for you? Group number one, I'm going to call out your names. Please say present, unmute yourself and say present before you start presenting. Who is sharing their screen? Brett Atuli, if you're in class, say present. Bet.
It's Brett.
If I don't hear from you, I'll mark you absent. Bet.
It's Brett. Present.
Bet.
Present. Don't know if you can hear me. Present.
Oh, my dear. Allow participants to unmute themselves. He's talking. I can't hear him.
Present.
Oh, people are talking and I can't hear. Then I will. It seems my speaker has a problem. Select a microphone. Give me a minute. I'm going to do what? Nicole Muswanya. Let me search for Rebecca. Some of you are very cheeky. Rebecca, I'm going to make you the host, a co-host, make co-host. That will allow me to leave the room. Okay. Brett Atuti, can you hear me now? Brett, can you hear me?
Yes, I can hear you.
Oh, okay. I can hear you too. So you're present. Good. Group number 1, you're present. Present. And then Khalid Abdi,
Yeah, present. Can you hear me?
David,
Present.
Derek,
Present.
Joshua,
Present.
James Borrow, absent. Okay. Papa Blaze,
Present.
Nathan, absent. Kibet,
Present.
Ali, Yasin, absent. So this is group 1. How many? 3 members are absent. So proceed. Group 1, proceed. Thank you so much. Proceed kindly.
Excuse me.
Yes.
James is in the waiting room and you haven't admitted him.
Who is in the waiting room?
In Boro.
Oh, okay. Hello? Brett.
Yes.
Oh, I can hear you now. Please
Okay.
share your screen if you don't mind.
Uh,
Share your screen and start the presentation.
can you see my screen?
Yes, I can. Thanks. So that is James Boro present. I've seen him in the waiting room. So it's Nathan who is absent.
Hello.
Yes, proceed. Hello.
Oh, okay. Brett, you sorry.
Who is speaking?
is James.
Who is? Yeah?
James.
James, are you speaking or I can't hear you? Please speak up because I can't hear you from my end. Let me try and connect my speaker again. James, proceed kindly. Okay, group 10, you have group 1, you have 15 minutes and you've already wasted 2 minutes because I can't see who is supposed to present.
I think James has disconnected. Let me just start. So you're supposed to look at. Can you hear me?
Yeah, I can hear you. Yes.
Oh, okay. So you're supposed to look at the mandate and the structure of. We're supposed to look at the mandate and the structure of superior courts in Kenya.
Hmm?
It's me.
Oh, okay. He's back. So the structure of superior courts in Kenya, we have 3 of them. We have the Supreme Court, the Court of Appeal, and the High Court. So I've divided this kind of courts between us. So I'm going to pass on to my group members to start from there. So we have Supreme Court. Also, I think the one doing Supreme Court is not around.
You know what? Continue wasting time and I will tell you after 5 minutes to stop presenting. You know, as a group, it is anticipated that we'll have technical challenges. In fact, that is expected. If you're having a technical challenge, then the other member of the group to step in because maybe they have dropped given internet connection. Okay, so just step in naturally and continue. Stop wasting time and waiting for the other person, yet they don't have internet connection.
Okay.
Well, I'm trying to share, but it can't share.
Because someone is already sharing. Oh, so that the person who has dropped off is a Tuti.
No, I'm the one who is sharing. So maybe I can just let the guy continue.
Okay.
Yeah.
Oh, just go to the first slide. Just start all over again. Right. So, good afternoon. I hope you can all hear me now. We'll be talking about the structure of superior courts. We'll cover the Supreme Court, the Court of Appeal, and the High Court. Next slide. So, for the Supreme Court consists of Chief Justice, who is also the President of the court, and the current one being Honorable Justice David Maraga. I'm sure we've all heard of him at some point in news or something. He was appointed in October 2016 and is set to retire in 12th January next year as he turns 70, because the Constitution stipulates that the Chief Justice is not supposed to be over 70 years. The next one is the Deputy Chief Justice, who is Honorable Lady Justice Philomena Mbete Mwilo. She deputizes the Chief Justice and is the Vice President of the court, followed by 5 other judges: Honorable Justice Mohammed Kadha Ibrahim, Honorable Justice Dr. Smokin C. Wanjala, and Honorable Lady Justice Njoki Susanna Ndongo. Honorable Justice Isaac Lenoala, and Honorable Justice Professor J.B. Ojwang. Next page. I think someone else is covering this.
I'll be covering the mandate of the Supreme Court. And basically, mandate means a judicial command that the court has authority to give to an individual. So, the Supreme Court is established under Article 163 of the Constitution, and it's the final interpreter. It comprises of the Chief Justice, Deputy Justice, and the five other judges. The Supreme Court has exclusive original jurisdiction to hear and determine disputes relating to the elections to the office of the President arising under Article 140 of the Constitution. Also, it has appellate jurisdiction to hear and determine appeals from the Courts of Appeals and any other courts or tribunals as prescribed by national legislation. However, appeals can only be as a matter of right where the case involves application of the Constitution or a matter certified by the Supreme Court. Also, the Supreme Court may review certification by the Court of Appeal and either affirm or overrun it. It can also render advisory opinion at the request of the national government or any county government with respect to any matter concerning county government. It can also determine the validity of a declaration of a state of emergency or extension of such a declaration or any legislation enacted or action taken in consequence. And finally, it can appeal from a tribunal constituted under Article 168 of the Constitution on removal of judges from office. The next slide.
Okay, so I'm going to take you through the Court of Appeal. If you can remember correctly, before the 2010 Constitution, the Court of Appeal was the highest. And then after then, the 2010 Constitution, after the old guys went and signed new referendum, we got to the Court of Appeal was pushed to be the second highest after the Supreme Court. It was formed under the Article 164 of the Kenyan Constitution, and it has a number of judges being not more than 12, not fewer than 12, and not more than 30. Currently, the court has 15 judges. Namely, I'm going to name maybe 3 who are very common. We have Justice William Ouko, who is the president of the Court of Appeal. So the president of the Court of Appeal is elected by the judges themselves. Number 2, you have maybe Justice Pasame, who is the commissioner of the Judiciary Service Commission. Another judge that maybe some of us know is Justice Altima, who is the director of the JTI. So the Court of Appeal is decentralized and has 6 registries in Kenya, in Nairobi, Mombasa, Nyeri, Kisumu, Nakuru, and I think Eldoret. So the mandate or the jurisdiction that is allowed for the Court of Appeal according to the Constitution is first called appellate jurisdiction, which means that it hears for appeals from the High Court, meaning that if, let's say, you are not contented with the decisions of the High Court, you can come and appeal that decision, this Court of Appeal, or maybe an act of Parliament, a tribunal act described by an act of Parliament. Second, we have original jurisdiction, which means it hears contempt of court. Contempt of court means it is an offense, disobedience towards a court of law. That is also a mandate of the Court of Appeal. So next we have High Court.
So for the High Court is established under the Article 165 of the Constitution, and basically the High Court consists of a maximum of 150 judges, and there are currently 20 High Court stations which are spread out throughout Kenya. And yeah, so the High Court basically is headed by a principal judge who has been elected by the other judges, and usually during the election of the principal judge, the Chief Justice is usually the head who has the election. And the roles of a principal judge is basically overall administration and management of the court, which basically is to take orders from the Chief Justice and pass the orders to the other judges, and ensuring the orderly and prompt conduct of business in the court, and undertaking duties that may be basically assigned by the Chief Justice. Then the High Court, next slide. The High Court has 3 jurisdictions, and the first one is the unlimited original jurisdiction, which is the inherent jurisdiction. So here, they determine all the criminal and civil matters and cases concerning the violation and infringement of Bill of Rights. So basically, the High Court usually takes cases regarding company law, copyrights, criminal law, tax law, insurance, property law, family law, and arbitration. And yeah, that's the original unlimited jurisdiction. Then there's the appellate jurisdiction, where the High Court basically appeals from subordinate courts and tribunals and on interpretation of the Constitution. And the last one is supervisory jurisdiction. This is where High Court has powers to supervise over the subordinate courts being the Magistrate Court and the Curtis Court and I think the Court Martial. Yeah. And I think that's it for the High Court. That's it. Yeah, that's it for High Court.
Take note of the judges of the Supreme Court. So in the Supreme Court, the President appoints the Chief Justice, the Deputy Chief Justice with the recommendation of the JSC, the Judicial Service Commission, and subject to approval of the National Assembly. And the other 5 judges are appointed in accordance with the recommendations from the JSC. So each judge of the Superior Court is appointed from among those who they have to have some of this, they have to meet some of this. So they have to hold a law degree from a recognized university, or are advocates of the High Court of Kenya, or possess the equivalent qualification in common law jurisdiction. They should also possess the experience required under the above clauses as applicable, irrespective of whether the experience was gained in Kenya or in another Commonwealth jurisdiction. And they should also have high moral character, integrity, and impartiality. So if we take the case of the Chief Justice David Maraga, he has 13 years experience as a High Court judge and a Court of Appeal judge. He has good public posture. He's known as a deeply religious and conscientious man. He's also famously said during an interview that he would never work on the Sabbath, even if an election petition were in progress. So he served also as an inaugural member of the Judicial Working Committee on Election Preparations before taking over as the chairman. So there are a lot of regulations that they have to meet to be appointed as a judge of the Supreme Court. So you can go to the next slide. So appointment of judges, you also have to be, you just have to meet these regulations, at least 15 years as a Superior Court judge. In the case of Maraga, he worked in the Court of Appeal. That's Maraga in the Court of Appeal, and in the High Court, at least 15 years experience, distinguished academic, judicial officer, or such experience in other relevant legal field, and he's held the qualifications above for a period amounting in aggregate to 15 years. We can go to the next slide. The judges of the Court of Appeal, they have to have at least 10 years experience as a Superior Court judge, basically the High Court, and they have to have at least 10 years experience as a distinguished academic or legal practitioner, or such experience in a relevant field, and they have to have held that qualification for a period amounting in aggregate to 10 years. So if you look at the Court of Appeal, the current president of the Court of Appeal is Justice William Ouko. And
You have 1 more minute. You have 1 more minute. Group 1, you have 1 more minute. Please wrap up.
Judges of the High Court have Ali Feni as the Supreme Court judge.
Go to your last slide. Go to your last slide, because we will not have one group presenting for 40 minutes. The final slide, please. Tenure removal from office. Okay, Sawa. Thank you so much, Group 1. Please, that will be all. Your time is up. The next 15 minutes, I want Group 2 presenting, or else we'll be here until 7 p.m. And I know most of you, I'm willing to be until 8 and to give you all the time. My fear is whether you are willing to be here until 8 o'clock. So let's wrap for Group 1 there. You've taken us through the superior courts. You got them correctly. The superior courts, or the superior courts, the Supreme Court, the Court of Appeal, the High Court. And as you close your presentation and allow Group 2 to present, I have a question for you. What is the criminal jurisdiction of the High Court? Group 1, that's a question to assess your understanding of what you're presenting. What is the criminal jurisdiction of the High Court? Please answer that question as we have Group 2 take over. Group number 2, please come on board. Group 2. I think about my question. I will call Group 2. Alan Vikiru. Alan Vikiru?
Present.
Daniel Olamide? Absent. Nicole?
Yeah, I'm here.
Okay. Daniel, please respond quickly because we don't have time. You're the same student who will be making so much noise if I keep you here. Nicole Muswanya? Present was yours. Nicole, such a response is a good one. Stephen?
Present.
Okay. Sichangi?
Present.
Edmond? Edmond?
I'm here.
Magnus?
Present.
Who's sharing their screen? Purity? No, Purity is absent. The way she has a lovely name. Jesse? Tagus, please speak. I see you have raised your hand. Jesse Matete? Matete? Vanessa?
Here.
Okay. Jesse is absent. Purity is absent. Vanessa is present. Yeah. Please, Edmond, talk to me. I see your hands raised. Papa Blaze, you want to answer my question? Please answer, because if you're not answered, I will deduct 2 marks from the general mark I'll give you. Yes, Papa Blaze?
Thank you. Okay, so for the High Court, it's actually the question about the jurisdiction. It's actually limited to any criminal case and civil matters, apparently. So in this case, and also it also takes in cases from, let's say, the lower courts, commercial courts, Catholic courts and stuff.
Okay, Papa, you have it halfway. You have 50%. Let someone take it home to 80. It doesn't have to be 100. Because the question is, what is the criminal jurisdiction of the High Court? That's the question. So you have said it can the High Court listen to any criminal matter? Or does it listen to only specific criminal matters? That's what I noted as a gap in your presentation. You didn't really bring out the jurisdictions, the powers of the court, and what cases they can hear, what cases they can't hear. So Papa Blaze, redeem your group.
Okay.
Can I answer?
Okay.
It can appeal cases from the High Court in any other court or tribunal prescribed by the Act of Parliament.
The High Court can hear cases from the High Court, or
no? The Court of Appeal can hear appeals from the High Court or any other court or tribunal.
Or any other court? No, not any other court, not a tribunal. No. You've got right High Court, but other court, other tribunals, no, James. David, I see you've unmuted yourself. What do you want to add?
So for the criminal jurisdiction of the High Court, I think the High Court can hear any case regarding criminal cases, but it's unlimited. It can hear anything regarding criminal cases. If that's what I understand by the criminal jurisdiction. And it can also,
Where that's noisy. Oh, that is you. The noise is amazing. Sorry. All right, I have muted everyone because of the noise. Papa Blaze.
Oh, sorry.
Really?
Just
David
adding
was on the right track, but I couldn't stand the noise from his background. It was doing me. Blaze.
Okay, just on to what my fellow group members have actually said. On top of that, the fact that the High Court cannot here listen to cases that include members of the superior courts in election petition. The ones then also it also hears to cases that conferred to Article 191, which is about the laws about sorry, I'm trying to forget it, but or conflict of laws. Yes.
So good attempt. I'll come back to that. Just because of time, let me allow Group 2 to take over. But we're coming to clarify on that question of jurisdiction of the court. But good attempt, everyone. Group 2.
Good afternoon.
Good afternoon.
We are Group 2. We shall be taking through the function of the Judicial Service Commission and the structure of the subordinate courts. So the Judicial Service Commission is an independent commission established under the Article 171 of the Constitution. Its mandate, as stipulated in the Article 172 of the Constitution, is to promote and facilitate the independence and accountability of the judiciary and the efficient, effective, and transparent administration of justice. Its membership comprise of the Chief Justice, who's the chairperson, one Supreme Court judge, one Court of Appeal judge, one High Court judge, one magistrate, the Attorney General, two advocates, one man and one woman, one person nominated by the Public Service Commission, one woman and one man to represent the public, now being lawyers appointed by the President with the approval of the National Assembly. So we shall go to the functions of the JSC.
Okay, I will be taking you through the functions of the Judicial Service Commission. As Dangus has already mentioned, was a part-time constitutional commission established under the Article 171 of the Constitution. So, what are its functions? To promote and facilitate independence and accountability of the judiciary and effective administration of justice. This involves roles such as the recommendation of personnel to the President for appointment, and also the reviewing and making recommendations on the services and conditions of service of this already existing personnel. For example, the judges, the judicial officers, the staff of the judiciary. Next slide. Then they also play a role in the receiving of complaints and the appointment of investigation officers to remove office staff from the judiciary. That is based on these complaints that are received. They can appoint or launch investigations to determine whether the complaints made were true. So after that, there is also the implementation of programs for the training of judges and other officers and other judicial officers, and also the advising the government on how to effectively administer justice. So apart from that, in performance of its functions, the Judicial Service Commission is guided by competitiveness in the appointment or hiring of these judicial officers, and also they're supposed to promote gender equality in the appointment process.
Cool. So moving on to the structure of subordinate courts. Subordinate courts established under the Article 169 of the Constitution in 2010. The forming subordinates to the High Court, first being the Magistrates Court. Then we have the Qadhi's Court, which I think, as we all know, is in regards to questions of Muslim law. Court martial, which is involved with military-related cases. Then we have complementary courts, the tribunals, local tribunals, as established by an Act of Parliament. Next, we'll have the martial courts, magistrates courts, sorry.
Hello, can you hear me?
Yes, I can hear you. Continue.
Okay, so the Magistrates Court, Article 169, 1A of the Constitution of Kenya 2010 creates the Magistrates Court, and this is where a majority of the judiciary cases are heard. And magistrate courts are generally located in every Kenyan district. So the authorities vary in administrative responsibility and range of fining and sentencing abilities. And the Judicature Act is the statute passed by Parliament detailing the varying powers and jurisdiction of magistrates and judges. So a magistrate court shall be subordinate to the High Court and will be duly constituted when presided over by a chief magistrate, a senior principal magistrate, a senior resident magistrate, or a resident magistrate. And it has both criminal and civil jurisdiction, which are as outlined in the Magistrate Courts Act of 2015. So next slide.
I'm going to take you through the criminal jurisdiction and the civil jurisdiction. So to start off with the criminal jurisdiction, we see that the magistrates court have jurisdiction and power in the proceedings of criminal nature as they may be conferred by the Criminal Procedure Code, Chapter 75 of the Laws of Kenya, or any other written law. So, and they're also restricted in the sentences they can pass. So, for example, depending on the charge, they can pass a maximum imprisonment of a term of 7 years and fines not exceeding 20,000 shillings. Next slide. In the civil jurisdiction, and so we can see that the court exercises jurisdiction over civil proceedings whose subject matters value from 5 million to 20 million shillings. This varies over who is presiding over the cases. So you can find that if cases over 20 million shillings, that the case is being presided by a chief magistrate. If it's 15 million shillings, it's being presided over by a senior principal magistrate. And the list is 5 million shillings, where we have the resident magistrate presiding over the case. So civil cases handled under, we can also see that there's also civil cases which are handled under the African customary law, such as land disputes and marriage and divorces, and dowry also. Next slide. We also have sexual assault and coercion, succession, orphanage and widowhood. We also see that magistrates court have a limited jurisdiction to hear and determine claims in employment and labor relations, land administration, management and environment, and climate protection. So as defined in the Industrial Court Act and Environmental and Land Court Act. So it's also important to note that they also have jurisdiction to hear and determine claims relating to violation of freedom from torture and slavery. Next slide. Next person.
I'll be taking you through the Qadhi's courts. In these courts, there should be a chief Qadhi and other Qadhis not fewer than 3. And a person shall not qualified to be appointed to hold or act in the office of the Qadhi unless, 1, they profess Muslim religion and they have knowledge of the Muslim law applicable to any sect of Muslims based on the opinion of the Judicial Service Commission to hold the Kadis Court. Then Parliament shall establish Kadis courts, each of which shall have jurisdiction and powers conferred on it by legislation. And the next slide. The Chief Kadi and other Kadis shall be empowered to hold Kadis court, and the jurisdiction will be based within Kenya. Then a Kadis court is limited to questions of Muslim law regarding personal status, marriage, divorce, or inheritance proceedings in which all parties profess Muslim religion and submit to the jurisdiction of the Kadis court.
So on to the next subordinate court is the court martial, which is established under the Armed Forces Act, Chapter 19 of the Constitution, and it hears cases of offences made by those who serve under the Kenya Defence Forces, that is the Kenya Navy, Army, and Air Force. The cases or each session can be convened by the Chief of General Staff or the various service commanders that are serving under the military, and each session will consist of a presiding officer and at least two other members. This composition, however, may change depending on some conditions. For example, if a relatively high-ranking officer is being tried and the maximum punishment of the offense that was committed is death, then we'd have the presiding officer and at least four other members. This presiding officer has to meet certain conditions that can be set by the convening officer, and they are eventually vetted to serve within the court. Some cases that are tried include collision with the enemy, that is, for example, assisting in the escape or giving away army secrets. Next is misconduct, which in regards to malingering. Malingering is the act of pretending that you're injured or you're sick with the aim of not serving. Drunkenness, looting, or destruction of property. Flying offenses such as flying too low or flying dangerously. Mutiny and the failure to suppress mutiny. This is arranged rebellion against authority with the aim of overthrowing the said authority. One can also be charged for having knowledge of such a plan and avoiding to obstruct. Next, we have insubordination, which is willfully disobeying authority, and desertion. Also, those individuals who assist those who desert are also subject to trial. The punishments that can be administered by these courts include death, imprisonment, dismissal from the defense forces, reduction in rank, fines, and stoppages. Stoppages are wage deductions, for example, a decrease in the health benefits as a worker. These sentences that are passed can be appealed to the High Court and directed to the Attorney General, and they must meet certain conditions as stipulated in the Armed Forces Act. That's it on court martial.
The final part that we'll be going through is the tribunals. They are established by Acts of Parliament to supplement ordinary courts in the administration of justice. They decide disputes in a particular area of law. They do not have penal jurisdiction and are mostly under supervision of the High Court. Decisions have to be in line with the Bill of Rights and the Constitution. There are about 50 tribunals in Kenya established under Acts of Parliament, with about 20 of them having been transited to the judiciary. In April 2017, the JSC established the Office of the Registrar of Tribunals, whose function is to coordinate affairs of tribunals. A few examples of these tribunals would be one for sports disputes, which is for appeals against disciplinary decisions for athletes, clubs, and the Anti-Doping Agency of Kenya. The HIV/AIDS Tribunal, which is basically for cases against discrimination on account of one's HIV status, and Rent Restrictions Tribunal that determine disputes between landlords and tenants. That's the end of our presentation. Thank you.
Thank you so much. That was excellent. That is good. Let me not exaggerate. Big words like Donald Trump was one. Sorry. That is good. Your presentation is good. I like the fact that you brought in the jurisdiction of the magistrate courts clearly, what their criminal jurisdiction is, their civil jurisdiction. So that's well attended. I want to just ask one member of the group, Blaze Hinga. I'm giving you a chance, Blaze. Let me deal with this group 10. Daniel Olaminde. Daniel, please tell me what is the jurisdiction, the civil jurisdiction of the magistrate's court. Daniel, what is the civil jurisdiction of the magistrate's court? Don't fail your group, because even if you've got it and you have not got it. Daniel?
Yeah, I'm thinking.
The success of your group rests on your shoulders, Daniel. As Daniel thinks, you can move to group number 3 because of
Okay.
time.
Yeah. So the jurisdiction is over civil proceedings that have a value between 5 to 20 million.
Okay. What do you understand by the word jurisdiction?
That is, those are the actual cases. If it was less than 5 million, they wouldn't have like a say or could not preside over it. And if it was about 10 million, yeah.
Huh? But what do you understand by the word jurisdiction?
I'd say like domain.
Domain, like in any, not domain name. Is it domain name for IT or not domain?
No, not domain for IT, domain for English.
Maybe powers. Okay, jurisdictions means the powers of the court, because a court can sit as a civil criminal court. So if it sits as a civil court, what kind of cases can it hear? When their word, if their word is over 200 million, then it's above what specific magistrate courts. Then finally, Daniel, that's good attempt. Let's go to someone else. We see if they'll be able to maintain the pace. Stephen Wanye, please tell me, what classes of the magistrate courts are there? I have seen that as a gap in your presentation. What classes, what levels of the magistrate courts are there in Kenya? Stephen Wanye. I should mark Stephen Wanye absent. Are you there? Stephen?
Yes, I'm here.
Sawa. Please nijibu. Stephen?
The classes, could you say the ones?
The classes, the categories, the levels of the different magistrates, the types of magistrates, however you want to put it. You have not brought that out in your presentation.
The type of magistrates, the chief magistrates, the senior principal magistrate, those ones.
Yeah. That's what I'm looking for. Did you discuss that in your presentation?
Yes, it was discussed under the levels based on the value of the court case, where we said if it's 20 million to the chief magistrate, if it's 15 million to the senior principal magistrate. It was said in passing.
All right. Thank you. That's what I was looking for. Thanks, Stephen. That's all for group number 2. I'm going to call out group number 3 very quickly because of time. Innocent Magode. Innocent.
Present.
Thanks, Innocent. Esther.
Present.
Keegan. Oh, Keegan is absent. George.
Present.
Carrie.
Present.
Daniel.
Present.
Jaden.
Present.
Rebecca.
Present.
Maina.
Present.
Okay. Only one person is absent. That is Keegan Kidua. So the rest are present. Please start.
Can you see my screen?
Let me close this participants list. Rebecca has started sharing. It's still loading from. I can see it now. I can see it now. Very nice slide.
Thanks. Our group is doing civil procedure, and so we'll start by first defining what a civil procedure is, and it's basically where person A sues person B for some sort of wrongdoing on their part. These are the presenters for the day, and we'll start with Esther Njoroge, and she'll give us an overview of essentially what it is.
Hi everyone, I'm Esther. So I'll take you through the first two procedures, and I'll give you a brief introduction to what a civil suit is. So I want us to think of Mumias Sugar and the residents, the Kakamega residents, yeah. So assuming Mumias Sugar was discharging its effluent on into a river in which the residents around the company are using it maybe for some like cleaning and everything, yeah. So and given that it's discharging this effluent, and it's affecting the residents since maybe they consume the water from the river, and it causes health issues and everything, yeah. And maybe a chief decided to go and take this into action, yeah, and so Mumias Sugar for doing that because it's maybe violating the right to a clean and healthy environment to the residents surrounding it, yeah. So this will bring a reason why the company will be sued, yeah. And basically this is what the civil suit entails, yeah. So in this case, Mumias will be the defendant, and the chief or maybe the residents will be the plaintiff, yeah. And we can go to the next slide. Go to the next slide. Yeah. So the solution will be maybe trying to settle it amicably, yeah, or try the alternative dispute resolution, and sometimes going to court in case the case is a bit severe, yeah. Can go to the next slide. So court annex mediation is also a way to provide a solution in case such things happen, yeah. Because sometimes there are many cases and maybe the court finds it hard to tackle each and every case. Court annex mediation is also a way to solve this problem, yeah. Can you go to the next slide? So the first procedure will be the client interview, yeah? And the main objective of this interview is to create the advocate-client relationship, and in this case, yeah, the plaintiff is the client, yeah, and setting the case, trying to bring out the issue, yeah. The main thing is to create just a rapport, yeah, knowing the client and reduce the client's anxiety without being unrealistic, yeah. Go to the next slide. Yes, a sample of questions that will be asked to the client will be: have you ever worked with an attorney before? Did you decide, or why did you decide to pursue this matter? Yeah, tell me about your case. So it's just creating a rapport, knowing everything, yeah. Another thing, no major decisions are made at this stage, yeah. Unlike the next stage, which is the pre-trial preliminary considerations, yeah. Yeah, and in this at this stage, yeah, we check what you call a cause of action. Yeah, cause of action is the legal right on which a claimant sues now the defendant, yeah, or just sues, yeah. So in this case, the plaintiff has been the right to a clean and healthy environment has been neglected, yeah. And at this stage is where we really check this case, yeah. Is it worth going forward with it, yeah? What are the reasons, what are the elements that should that make this case strong, yeah? Because here the health of the residents is at stake, yeah, and it's something that's worth being looked into, yeah? So we can go to the next slide, yeah? So things that are looked into at this stage is like the time limitation, yeah? Time limitation is where the cases which have different, take time, maybe duration, yeah? There's some cases that take 6 months, 3 weeks, yeah? The feasibility of the lawsuit, determining the existence of a course of action. Can you go to the next slide? Yeah, turning down the case. Is it worth going forward with it or not? Yeah. So this is where we really check the severity of the case. Yeah, checking each and every element. What did the defendant fail to do, or which was required of them to do? You know. Yeah, but like ensuring maybe the environment is clean. Yeah, whatever they're doing isn't really affecting the resident, or maybe it should be benefiting the residents around it. Yeah, you can go to the next slide. Yeah, it's okay. You can just move on. So Becky should kindly read this question for us, just to give us a basic overview. Yeah, this is just like a small case, yeah? Yeah, just to introduce you, or just to give you a basic overview of what really happens at this stage of the civil procedure.
So suppose that Juma drives his motorcycle negligently and fails to stop at a stop sign. He's hit by Somi, who is driving in accordance with all the traffic laws in a careful and prudent manner. Juma is the only one injured in the accident. Can Juma recover his damages from Somi? Any take?
Yeah. You can just move on because of time, yeah? And then you can answer it later on.
Okay, so I will be taking you through the next part, which is the demand letter. And first of all, once the first stages have been done and a course of action has been set, they'll be writing a demand letter. So the question is, what's a demand letter? And in short, it's a notice demanding that whoever it's being addressed to perform an obligation, such as fixing an issue, paying a sum of money, or honoring a contract or a contractual commitment on specific terms. And it also gives them a chance to perform the obligation without being taken to court. In certain types of legal proceedings, it's mandatory, where a demand is required to be made as a matter of law. And it's important to put the demand letter is sent before the start of the suit. And there is a time frame within which a response is required. And it's now become a compulsory document within the civil procedure rules in 2010, according to Order 3, Rule 2D. And another thing to note would be that an important thing to be known is that it's now become compulsory according to the civil procedure. Yes. So the next thing is how to approach the court. And the first thing is originating an action. So legal proceedings are usually commenced when the plaintiff makes a complaint. So in this instance, person A wronged person B. So person B will now make the complaint. And pleading, the action will contain information as to which the circumstances it alleges. For instance, person A hit me. That's what person B would write in the when they're writing the complaint. And what are pleadings? They're written statements of parties to a suit which are served on each party. And normally this is a statement of pleadings set in summary form from the nature of the case and the material facts that support the claim. Normally, also it's important to note that in terms of the statement of origin, this statement of pleading sets in summary form the nature of the case and the material facts that support the claim. Legal proceedings can be commenced as a way of plaint, originating summons, notice of motion, or chamber summons, etc. So you would have to also provide the evidence of that you're alleging. And the second part is filing of documents. So order two, sorry, this is supposed to be order three. Order three, rule 3, points that a register of suits to be called. The register of civil suits shall be kept at every registry. The particulars of every suit filed in a registry shall be entered in the registry. Further, every plaint to the file shall be presented to the registry during office hours. It will have the fee payable upon filing and a date stamp on the date which is to be presented, which shall be the date of filing the suit, notwithstanding any dispute as to the amount of payable. And now we'll move on to part E, which is going to be done by Jaden.
Okay, so I'll be taking you through the next part. Please go to the next slide. So first we'll cover what a plaint is. And as Rebecca already gave what a pleading is, a pleading is a statement. And now the plaint is also a pleading, but this states the basis of the lawsuit. And it's the most widely used pleading for a civil suit. So what does the plaint contain? The plaintiffs, who are like the quote-unquote accusers, and the defendants, who are quote-unquote the accused, the status and the capacity to be sued, the factual basis, a request or demand for relief from the court, and a statement showing the selected court has the appropriate jurisdiction and venue. So for the example, in the example Esther gave earlier for Mumias and the villagers, the plaintiffs will be the villagers, the defendants will be Mumias, and the status and capacity to be sued and to be sued. Like for example, whether the company will be bankrupt or not, and moving on henceforth like that. So for the next slide, it's not going to be about summons. Please move on. Okay, so these are summons. So summons are filed alongside the suit, which also prepared by the plaintiff or his advocate. So the location of the defendant is also known in the summon. So they'll have to attend for the civil suit. So it's mandatory that the summons is signed and sealed within 30 days of filing. And the summons shall be collected for service within 30 days and are valid for 12 months. But this valid period can be extended by the courts after an affidavit is filed. So if no application of extension is made, the suit can be dismissed upon the expiry of 24 months.
So I'll be
Thank you
taking
very
you through.
much, Jaden. Next is Kaji.
So I'll be taking you through part G, which is responding to pleadings. And next slide. So we have the written statement of defense. So what is this? So this is a pleading presented to the defendant, intended to traverse.
Just to alert you on time, I can see you only have 3 more minutes, so please manage that very well.
Okay. So this is a pleading presented by the defendant, intended to traverse the allegations on the plaint. So the function of this statement of defense is to state the grounds and material facts on which the defendant relies for his defense. It also informs the plaintiff precisely how much of the statement of the claim the defendant relies on to defeat the claim of the plaintiff. Then you have striking out pleadings. So the court may, at any stage of the proceedings, order to be struck out or amended any pleadings in an action or anything, any pleading on the grounds it discloses no reasonable cause of action or defense. If it is scandalous, frivolous, and vexatious, it may prejudice, embarrass, or delay fair trial, or it is an abuse of the process of the court.
Next, we'll have Jessica explaining the third-party notice.
So for the third-party notice, this might be where the defendant claims against another party who's not already involved in the suit. The defendant can be offered some retribution. The defendant is entitled to contribution or indemnity where they can allow the defendant can sue other parties for a portion or the entire amount of the damages caused by the suit, is entitled to any relief or remedy relating to the original subject matter of the suit and substantially the same relief claimed by the plaintiff. If the issue connected with the said subject matter is substantially the same issue between the defendant and the plaintiff, then it should properly be determined between all three of them or any either of them. So the defendant applies for a leave within 14 days. That's on the next slide. Yeah, after the close of pleadings for leave of the court to issue a notice. So the leave is applied for by summons in chambers ex parte with absence of other members, supported by an affidavit, that's the testimony. When the third party claims against any person not already a party, then the provisions of this order shall apply mutatis mutandis. That is, the same rules applied to that person as a third party shall be applied to the other person, and it shall be a third party in that case as well. So in case the third party is the government, the court might not grant the leave to issue a third party notice unless the government has the information necessary in the case, or the liability of the government or any department or officer in the government has arisen. So for interlocutory...
All right, your time is up. Your time is up. We can't allow a group to present for more than 20 minutes because other groups are waiting to present and we don't have time on our side. So what do you do? Go to your last slide. Wow. Already. Go back a little bit. Back. Can we discuss a little bit on execution and decree? Judgment and decree? 1 minute. Wind up.
Okay, so when it comes to judgment and decree, essentially this is where it comes to the final judgment of the lawyer. So in judgment and decree, once a hearing is completed, the court will have to pronounce the judgment, and rules 1 to 6 of Order 21, the Constitution, deals with judgments, and rules 7 to 19 of the same order deals with decrees. So it's like they follow each other. And then a judgment is the final decision of the court on the facts of the case at the end of the whole court procedure, the whole suit. On the other hand, a decree is a technical translation of the judgment capable of execution. In the High Court, parties themselves drop the decree and take it back to court to be sealed, and it should be in agreement with the judgment. So, for instance, if person A had person B, like let's say they shot them, and then person A suggested that they could the judge, let's say, says that you have to compensate this person. So maybe person A would reach out and say, can I pay your medical bills or something of the sort? Then the person B would say that would be better. So that would be the decree section of it. Yeah.
Thank you, group number 10. Sorry, no, group 3.
Sorry. Any questions?
No, I will not even allow further people to ask you questions because there's no time. I will just, request you to wrap up there. Let's have the other group. It is very important. You have good presentation, but now you're going to lose a mark because you didn't manage your presentation very well. The slides are excellent. I really like the slides. You should show me how to do that. But Sasa, where you have a lot of information I've seen, you've taken it all the way from when a case arises to until when they even have to appeal. So I think there was a bit of, you needed to hive off some information so that you can present it within time. But thank you for the hard work. I can totally see the hard work, and because of that, I will not ask you many questions. I will turn to group number 4 so that they can start us off. Miriam, are you present?
Present.
Helen.
Present.
John.
Present.
Moses.
Present.
Emmanuel.
Present.
Joan.
Present.
Lorna.
Present.
Then we have Hildegard.
Present.
Thank you. Group 4, please continue.
Okay, we're doing criminal procedure, and these are the members. So we have criminal justice systems, trial process, judgment, appeal, and special procedures. John will start off.
I hope you can hear me.
Yes, we can. Please proceed.
Audibly. Okay, let me start. So I was going to take you through the courts involved in criminal cases and their jurisdictions.
Skip the courts. We have already had group 1 and 2 discuss the courts.
Yeah,
so just skip the courts.
Okay. Sorry. So I'll take you through the procedure between when a criminal case starts until when an accused person makes a plea. So a criminal case can start either when a complaint is made to a magistrate or when a person is arrested without a warrant. Next slide. So in the case of a complaint, it is made to a magistrate, either in writing or orally. And if the magistrate finds that the complaint discloses an offense, then the magistrate will cause to be drawn up, or he will draw up and sign a charge sheet stating the offense is committed. Then after that, the magistrate may issue a summons and a warrant of arrest. The next slide. Another way a criminal case can start is when a person is arrested without a warrant. So this may happen in various circumstances that I won't talk about, but you can see them in section 29 of the Criminal Procedure Code. Okay. Either way, when you're arrested, you should be presented to court within 24 hours. So yeah, within 24 hours, of course, unless in various special circumstances. So in your first court appearance, you should be informed of your right to legal representation if you don't have a lawyer. So that's in accordance with the Legal Aid Act. And also the courts must ensure that you understand the language of the courts, either Kiswahili or English. If you don't, then you will be provided with an interpreter, of course at no cost to you. But the most important thing that happens in the first court appearance is that you are informed of the charges that have been brought against you. Next slide. So once you know your charges, then you'll be asked to plea. You can either plead not guilty, or guilty subject to a plea agreement. That's according to section 201, subsection 1 of the Criminal Procedure Code. Yeah. Next. So when you not a previous. When you plead not guilty, the court proceedings will proceed as usual. The complainant will be heard, his witnesses will be heard, and the evidence will be presented. And also the accused person will have the right to question the witnesses that have been brought against him. Next. So when you plead guilty, then the court will make sure that your admission to guilty is unequivocal. It is completely unambiguous. So that's what the first 2 points states. So if you plead guilty, a plea of guilty will be entered, and you will be convicted and sentenced on that plea. However, just go to the next slide. The next person can continue.
Okay, so I'll take you through the trial part. This is just some processes that we pass through the trial. Can you please next slide? So the public trial. So what happens here is that a criminal trial must be held in public as a general rule, although the limited circumstances in which closed proceedings are allowed. So the grounds upon which the court can exclude the public from the trial is that to protect the witness or the vulnerable person, to protect the morality if satisfied that the evidence being adduced, then to protect the criminal order and to protect the national security. Next slide. So the attendance of the parties, the attendance of the accused person, here are just some of the steps that are included. The accused person has a right to be present throughout the trial. The court may be waived the presence of the accused person if after receiving summons to the appeal for a misdemeanor charge, the accused either pleads guilty or in writing or is represented by an advocate. Then a warrant of arrest may be issued for an accused person. The warrant of the arrest may be issued for an accused person who was served with the summons to appear but failed to do so. And an accused failure to appear for a hearing is treated differently depending on whether the case is a misdemeanor or a felony. Next slide. So, however, the discretion to proceed in the absence must be exercised with the caution. So, on the complaint attendance, when an accused person appears for a hearing, but the complainant who had notice of the time and place appointed for the hearing fails to appear, the court has the discretion to acquit the accused. Next slide. And the word complaint refers to either the republic or the person who filed the complaint. So if it's necessary, a victim can be provided with a reasonable out-of-pocket and travel expenses to attend the trial, and the power to dismiss a charge or acquit the person following the failure of the complaint to attend the court should be exercised with a caution. Next slide. So expeditions. Conduct of trial. A trial must be concluded without an unreasonable delay. Whether a trial has been concluded without unreasonable delay is determined on a case-by-case basis. Then courts are obligated to conclude the cases that involve vulnerable persons, such as the children, the elderly, and people with intellectual disabilities. The anti-corruption court is required to hold on a daily basis until the conclusion, as far it is practicable to do so. The court is required also to, as far as practicable, to proceed on the daily basis until the conclusion of the trial. Next slide. The adjournment of the hearing. The court's discretion to grant or refuse an adjournment has to be exercised. The adjournment are available both to the prosecution and to the defense, but neither the prosecution nor the defense is entitled to indefinite adjournment. Next slide. The termination of cases. So on the part of the termination of cases, the termination by the director of the public prosecution. So on the article as 176.6c of the Constitution empowers the DPP to discontinue at any stage before the judgment is delivered. Then the DPP is required to obtain the court's permission before they discontinue prosecution. And the magistrates courts, the prosecutor, with the court's permission, can withdraw proceedings at any time before the judgment. Next slide. So the withdrawal of the complaint by the complainant. Under the section 204 of the CPC, the complaint may withdraw the complaint before the court passes a final order in the case. The court held that if a victim requests that a case be withdrawn, the victim must seek withdrawal from the prosecutor. Then, in case of the death of the accused the criminal proceedings are terminated. Next slide. Yeah, so the case management, before the trial begins, the court should hold a pre-trial conference to address preliminary matters and make necessary arrangements for the trial. So the court should address the following issues before preparing for the trial: the disclosure of the evidence, protection of the vulnerable.
Stop there, please. Stop there. Stop there. Sorry for that. You're on a wrong path. You're on a wrong path. So I don't want you to continue on that wrong path and get lost. Case management is important in civil or criminal, but we don't do things like disclosure of evidence. Not in criminal case. Why should you go and tell the prosecutor, give the prosecutor evidence if you're on the defense side? This is not applicable in Kenya. This information is incorrect. Go to the next slide. Next slide. Taking evidence. Next slide. Sorry. I might have to stop your presentation here. Next slide. Next. Whoa. The hearing, the judgment. Let's start. The rest, please, are incorrect. The evidence part might be correct, but I don't want to let you talk about evidence. So go to the hearing, start from there. The rest is not relevant. Even evidence, you don't have to. We just want to know the procedure. The law of evidence is not the subject of representation here. So let me hear from here, the hearing.
Hi, I'm Lorna and I'm going to take you through the hearing. Please move to the previous slide. Previous. Yes. So the first one is conduct of the prosecution case. The prosecution must prove the guilt of the accused beyond reasonable doubt. And after that, there is the opening speech, which the prosecution may make an opening address when it opens the case against the accused person. And the opening address sets out facts which the prosecution seeks to prove and ought not to contain any reference to evidence whose admissibility is open to challenge. Next slide, please. Then there's choice of witnesses. The prosecution has a duty to call all witnesses necessary to establish the truth, even though the evidence may be inconsistent. Then there is order of witnesses. The prosecution determines the order in which the prosecution witnesses are to appear, and there is cross-examination by defense and re-examination. So after cross-examination, the witness may be asked further questions regarding about the case going on. Next slide, please. So there is questions from the court, and the court may put any question to the witnesses that are necessary for the just decision of the case. And the defense witnesses, the accused retain his or her right to call witnesses. Then there's clause of the, a minute please, there's clause of the defense case where the defense closes its case prematurely. For example, because of denial of an adjournment to call further witnesses, or for want of attendance of witnesses, or for other reason, the court should note that fact on the record. Then the last part, final submissions. At the close of the case, both the prosecutor and the accused are entitled to present submissions to the court on both the evidence. Yes. Next person can present. Thank you.
Okay. You have 1 minute, 1 minute, 1 more minute. So please make the most of this 1 minute. What? Kindly.
So we have contents of judgment, which include every judgment must be written by or under the direction of the presiding judge or magistrate, who must sign the last page, and the court is required to sign and date the judgment. The pages should be numbered consecutively. Next slide. So for imprisonment is an act of confining someone in a prison or as if in a prison. So upon imposing a prison term, the court must issue a warrant ordering that the sentence be carried out in Kenya, and the court no longer has jurisdiction over the case. However, it bears supervisory role over the prisons. Next slide. Next slide.
Sentencing, that is the last. Let it be the last slide. Sentencing, kindly.
Oh, okay. Previous slide. Oh, okay.
Already. So number, there's no point continuing further. Please, I don't know what feedback to give you. I don't want to dishearten you. I know you went into it and you looked for information, but most of the information you're sharing, I just wanted a simple, straightforward explanation of the criminal procedure in Kenya from step 1 to the last step, not taking of evidence. Some of the information you have is incorrect. We don't have case management in criminal cases unless it's another jurisdiction. Are you Kenyans? Unless you're not Kenyans. So not even right, not even appeal. So you have to go back and do your presentation. You have to go back and give me the information I need. In the meantime, you lose a bit of marks because of this. Sorry, I know I can see the hard work, but it is not correct. So it's very painful for me to do this to you. Lakini, just go back. Instead of me grading that slide that it is, please go back. I have information on, go to e-learning. When we were discussing the first topic, sources of law, look at the slide, the information I've attached there on criminal litigation. Let it be a guide so that you can remove what needs to be removed, add what needs to be added, so that you have correct information for group number 4. But thank you. We are all learning, okay? We are all learning, so I don't want to be hard on you. I don't want you to be hard on yourself. We're all learning. So that's my comment for you, group number 4. We can have further discussion in the course of the class or after the class if you have further questions for me. Sorry about that. We'll go to group 5, which is in ICS B now. We are moving to ICS B. That is, why is it, it's written 6, so I don't know if this is 5 or 6. 5. You've class, oh, so you were, okay, then you're 5. Afandi Indiazi.
I'm present, but I'm in group 6, not group 5.
Who is in group 5?
Group 5 with Steve Nyaga and Stacey Owen.
There's group? Okay, let me just Ole with I see group 5 now. I will call it in a minute. So that was okay. Lewis Maina?
Yeah.
Excuse me. Lome?
Present.
Stacy? Alvin?
Present.
Kelsey?
Yeah.
Jesse?
Present.
Jeffrey?
Present.
Steve? Victor?
Present.
Brian?
Present.
So the only person who is absent is Steve.
Steve is here.
Present.
Please, Steve, I heard your voice very faintly. Please talk like you have life in you. Talk with a bit of strength. Hey, that was very faint. I don't know if it's the internet.
Can you hear me now?
Yeah, I can hear you clearly. Yeah, that is the voice of.
Okay, so I'll be the one starting the presentation. We'll be working on a mandate, composition, and the role of the National Assembly. Let's start. Next slide. So, what is a mandate? A mandate is a judicial command, order, or precept, written or oral from a court, a direction that a court has to obey, the authority to give, and an individual is bound to obey. Three things are necessary to create a mandate. First, there should exist something which should be the matter of the contract. Secondly, that it should be done gratuitously. Thirdly, that the parties should voluntarily intend to enter into the contract. So government bodies draw their mandate or operational capacity from the Constitution of Kenya. Next slide. So next up, we want to talk about what the National Assembly is. So the National Assembly is the Republic of the Republic of Kenya, is the lower house of the Parliament of Kenya. Article 95 of the Constitution establishes that the National Assembly should consist of the following: 290 members, 47 women, 12 members nominated by the parliamentary political parties, and the Speaker, who is an ex-official member. So if we look at the mandate of the National Assembly, as mentioned earlier, the government bodies draw their mandate from the Constitution. Article 95 of the Constitution states that the following should be the roles of the National Assembly. National Assembly represents the people of the constituencies, for example, the 6 reps of Mombasa County, and special interests, for example, minority parties in the National Assembly. The National Assembly deliberates on and revolves issues of concern to the people. The National Assembly enacts legislation in accordance with Part 4 of Chapter 8, which is known as the Legislature of the Constitution. Next. The National Assembly also determines the allocation of national revenue between the levels of government as provided in Part 4 of Chapter 12 of the Constitution. It also provides funds for expenditure by the national government and other national state organs. It also exercises oversight over national revenue and its expenditure. Next. The National Assembly also reviews the conduct in office of the President, the Deputy President, and other state officers and initiates the process of removing them from office. It also exercises oversight of the mentioned state organs. The National Assembly, lastly, also approves declarations of war and extensions of states of emergency. Next.
So looking at the composition of the National Assembly, just as Brian has mentioned, next slide, please. So the National Assembly is composed of 349 members. Usually when you hear people speaking of 350, maybe they are confusing of the Speaker, who is an ex-official member. So among the 349 members, 290 members are elected from the constituencies that were established by the IEBC in October 2012. So these are 290 members elected by registered voters. And then Article 97 of the Kenyan Constitution creates the position of women representatives. These are the 47 women reps. It stipulates in Section 1B that the membership of the National Assembly consists of 47 women, each elected by the registered voters of the counties. Each county constituting a single member constituency, therefore guaranteeing a minimum of 47 women MPs in the National Assembly. They receive and act on petitions from the public on matters that relate to women and girls and discrimination of women and girls. There are also 12 representatives of special interest who are nominated by parties based on the number of seats they control in the body. And finally, the Speaker of the National Assembly, who is an ex-official member. Next slide, please. As we continue to look at the roles of these members of the National Assembly, we need to remember that there is the 2/3 gender rule that is established by Article 81B, which states that not more than 2/3 of the members of the elective or appointed bodies shall be of the same gender. So the roles of the 290 elected members from the constituency is to determine the allocation of national revenue
between the levels of government, deliberate on and resolve issues of concern to the people, appropriate funds for expenditure by the national government and other state organs, review the conduct in office of the president and deputy president. Okay. Sorry, can you hear me?
Yes, I can hear you.
I hope you can hear me. And finally, it approves of declarations of war and extensions of state of emergencies. This will be discussed further in roles of National Assembly.
Okay, so I'll take you through the next section. The 47 women representatives. This position is the outcome of the two-thirds gender rule that aims to increase the representation of women in parliament. Their roles are covered below are to promote the interests of women, girls within their counties, to come up with policies that specify.
So among the 47 women reps, they promote the interest of women within their counties. They come up with laws and policies that specifically target women and girls. They also receive and act on petitions from the public on matters that relate to discrimination.
I wonder if Stacey can listen to the rest of us. What's happening right there? Who is presenting?
Sorry, I'll continue here. The 47 women reps promote the interests of women and girls within their counties. They come up with laws and policies that specifically target women and girls.
My dear, how can someone just be presenting and she can't hear us?
Okay, I think she has a problem with her speaker, but let me just proceed on to save one time. She had covered, I think, the first three. So the fourth one is mobilizing residents in their counties to identify projects that women and girls can benefit from, influencing also government to include these projects in their budget. The main role for these women representatives isn't necessarily to provide or meet these immediate needs for women and girls, but they should actually advocate for the long-term policy interventions to find solutions to challenges facing women and girls. Next slide. Okay, then the speaker who we discussed is an ex officio member, basically a person who's a member by virtue or their position is they hold that position based off of their current status. Their role is to direct all activities of the National Assembly and its committees and presiding over the proceedings of the House under the rules of the National Assembly. Secondly, interpreting all matters touching on the application of procedures and practices of Parliament at all times. Thirdly, in cases where matters are not in cases where they can't come to a conclusion, they by virtue come up with a verdict based on the Constitution, statute laws, precedents, custom procedures, and traditions of Parliament. Fourthly, they chair the housing committees that we'll see later on. And they are the official spokesperson.
5 more minutes.
Okay. I just said the last point, administering.
5 more minutes, and I just want to make sure you're doing the right thing by focusing too much on this. There are many other discussions to be made. So you have 5 minutes, spread it out nicely.
Okay. Let's just continue with the next slide. We as citizens can measure the performance of each members that we've elected through a document called the Hansard. It offers a sort of receipt of how each member that has been elected contributes to certain rules or bills that are passed in Parliament. We can basically judge them from their contribution and what they stand for and what they promise to stand for. Yeah. For example, a motion that was to set us members of the National Assembly who are women to look after their babies. It was earlier around this year. I'm not so sure if it was passed as a bill, but yeah, that's an example. Next.
Yeah, next we'll talk about the committees. They are established by they consist of a group of members appointed by the House to examine issues in more detail than in possible matter if the whole House had to be involved. Next slide. So the benefit of the committees is that they facilitate division of labor where several committees can meet at a particular time tackling various issues. They address matters in details in Parliament. They are more practical, and they are a good avenue for communication because they offer a platform for community to air their views. Next slide. Their functions include investigate and report government budget proposal, examine and report any bills or draft bills referred to them, monitor performance of government ministries, approve hearings for nominees appointed by the president. They review conduct of state officers and exercise of state oversight over state organs. They also approve national borrowing and sets public debt ceiling. And finally, they provide linkage between National Assembly and the electorate through public participation processes.
So there are 5 types of committees. We'll start with the departmental committees. This committee that's appointed at the beginning of each parliament under the National Assembly Standing Order number 216. It continues to function until the day before the general election and lasts for the lifetime of a parliament. It shadows the work of various national government departments and covers each area of government operation. I shall go to public audit committees, which are committees that act as the parliament's watchdog over the way taxpayers' money is expanded by the executive, judiciary, and the legislature. Ad hoc committees are temporarily formed for specific purposes and whenever there's a need for a specific task to be done. They often study a particular issue within the limited period of time and are established by a resolution of the House with specific terms of reference. When their task is complete, the committee is dissolved and they do not draft any legislation. Housekeeping committees, these are the committees that deal with the matters relating to internal operations of the National Assembly, including procedure, privilege, and the provision of other facilities in Parliament, amongst other things. These committees deal with the welfare of members and staff and inquire into matters relating to power and immunities of the National Assembly. And mediation committees is a committee that's formed to reconcile different versions of the same bill. They're established when the House doesn't agree to all or part of a bill that require concurrence of the 2 houses, or when a motion for the second or third reading of a bill, when a House rejects motion for the second or third reading of a bill originating from the other House.
I'll take you through the roles of the National Assembly. Next slide. Representing the people. So the members of the National Assembly represent the special interest of the people in the National Assembly. They also deliberate on and resolve issues that concern their people. Next slide. Legislation and oversight. The role of the National Assembly in public finance, there are 3 of them. To determine the allocation of national revenue between the levels of government, which are the national government and the county governments. This process is called the division of revenue, which is stipulated in the Article 217, which talks about division of revenue, and Article 218 talks about annual division and allocation of revenue. Next point, deliberate on a resolution by the Senate on the revenue sharing formula for the money allocated to the county government. Third point, division of revenue between the national and the county governments through the division of revenue bill. So the National Treasury Cabinet Secretary tables the bill before the National Assembly. They deliberate on the bill and then pass it on to the Senate. If both houses don't agree, a mediation committee is formed between them. Next slide. They appropriate fund for expenditure by the national government and other state organs, for example, ministries and departments. This is achieved through the annual budget, where it determines the amount that goes to each organ. It also exercises oversight of a national expenditure. It has power to summon government officials, including ministers, to answer on questions regarding expenditure. We have seen some cabinet secretaries being summoned by the National Assembly. The last point, it adopts reports on government expenditure from independent offices such as the Auditor General and the Controller of the Budget. It uses this report as a basis to summon officials to provide answers stipulated for the government expenditure.
So the National Assembly should debate bills that do not concern counties. These laws that don't concern counties should be those in line with government functions. A National Assembly nonetheless plays a role in bills concerning counties, the special bills and the ordinary bills. So for the special bills, they relate rather they are referred to in Article 218, and for the latter one, on the it originates from the Senate. So in this case, if 2/3 of the National Assembly support it, it proceeds. So here the National Assembly review the conduct of the office of the President, the Deputy President, and other officers, which include secretary, judges, and members of other commissions. So depending on the findings, it can lead to initiating a process of removing them from office. For state organs, it ensures that these organs operate within the law and do not infringe other state organs. And the final one, declaration of war and state of emergency. So the president is allowed to declare war, but he'll have to go through the National Assembly first for approval.
So the law making process, first there is the first reading. This involves introducing a bill to the National Assembly. Then the second reading, the bill is read for the second time. And then the third reading, the bill is read for the last time with all amendments and given approval. Then the presidential assent, the president gives its consent to an act of parliament. And then commencement, the public is notified of the date of the act coming into effect through legal notice. Next slide.
Okay, so I'll take you through the election qualification and disqualification of MPs next. Okay, for a person to be eligible to be elected, he must be a registered voter. He must be nominated by a political party and elected by at least 1,000 registered voters in a constituency. Next. During the election process, there has to be a vacancy in the office of a member of the National Assembly, where the speaker reads notice to the IEBC and the political party on whose party list the member was elected or nominated. Next. Whenever a vacancy occurs, within 21 days, the speaker needs to write a notice to the IEBC, and a by-election needs to be held within 90 days of the occurrence of the vacancy. A vacancy shall not be filled if there's a general election, if there's an upcoming general election in the next 3 months. Next. A person may also be disqualified from being elected if the person is a state officer, worked at the IEBC within 5 years immediately preceding the date of election, has not been a Kenyan citizen for at least 10 years immediately preceding the date of election, is a member of a county assembly, and is of unsound mind or mentally challenged. Next slide. Or if the person is also declared bankrupt, or if the person is imprisoned for at least 6 months when the person was elected as a candidate, or if the person is found in accordance with the law to have abused the state of office or public office in a way that might have contravened Chapter 6 of the Constitution that talks about leadership and integrity. Thank you.
All right, thanks, group number 5. That was good presentation. You have covered most of the areas that were expected for you to cover. Mandate and Article 35, composition of the National Assembly, and some of the specific roles it does, including lawmaking. So that's good, very good, in fact. Just a few questions for all of you to address. Not all of you, some of you, because of time, I can't ask each one of you. So let me call on Calvin Klein. Calvin, I want you to explain to me whether the parliament can remove the president from office. Is that possible for the parliament to remove the president from office?
I think so, because we've talked about they monitor people in office, including the president, the deputy president, and cabinet secretary.
So you feel it is very much possible for this to happen? Calvin?
Yes, I think it's possible.
Yeah,
And,
it is. Impeachment. Yeah, you're right. Let me not harass you. You're very right. Thank you so much, group number 5. Because of time, I will not ask you further questions. I will instead call group number 6 now from ICSB. We will start with ICSB. Group number 6, Afandi. Afandi, are you present? Afandi?
I am present.
Okay. Dennis Monique?
Present.
Caesar?
Present.
Samuel?
Present.
Philip?
Present.
Dennis?
Present.
Timothy?
Present.
Warui Timothy? Anita?
Present.
Present.
Madenge?
Present.
John?
Present.
All of you are present. Thank you. Please proceed with your presentation.
Hope you can see the presentation. Okay. Good afternoon, everyone. This is, and we are presenting about the Senate, its mandate, its composition, as well as its functions. So the first presenter will be John.
So we'll talk a bit about the legislature, which is the branch of government concerned with making laws. And Kenya uses a bicameral system, which means that the legislature has 2 houses, the upper house and the lower house. The upper house in Kenya is the Senate, and it usually has less power than the lower house, which is the National Assembly. Next slide. So the Senate is the upper house of Parliament in Kenya. It's first established in 1963, but it was phased out and it was re-established by the 2010 Constitution. The next speaker is Samuel. So the membership of the Senate is stated in Article 98 of the Constitution, and you can see the people, the 47 members, each elected by registered voters of each county, 16 women members who shall be nominated by political parties according to their proportion of members of the Senate under Clause A in Article 90. Then you have 2 members, one being a man and a woman representing the youth. Then 2 members, one being a man and a woman representing persons with disabilities. Then the speaker, who is an ex-official member.
Next.
Okay, so I'll just go through
So I'm going to take you through the functions of the Senate. The overall function of the Senate is to protect the interest of the counties and their governments. And the Senate also participates in lawmaking. of the Parliament by considering, debating, and approving bills concerning counties. The Senate also determines the allocation of national revenue among counties and exercises oversight over national revenue allocated to the county governments. The Senate participates in oversight of the state officers by considering and determining any resolution to remove or impeach the president or the deputy president from office.
So I'll go over the function of the Senate, which is lawmaking. In exercising its legislative mandate, the Senate considers bills that, sorry, go back to the slide before. Senate considers, debates, and approves bills. Articles 110 and 256 of the Constitution provide that bills that may originate from the Senate are: A. Bills concerning county government. Article 110 of the Constitution defines a bill concerning county governments as that which contains provisions affecting the functions and powers of the county government as set out in the 4th schedule, or relates to the election of members of a county assembly or county executive, or affects the finances of the county government. The process of passing bills in this category is guided by the provisions of Articles 111 through to 113 of the Constitution. B. Bills that propose amendments to the Constitution through Parliament as envisaged in Article 256 of the Constitution. Other than bills that originate from the Senate also considers bills that originate from the National Assembly but affects county government. They also consider bills that propose to amend the Constitution under Articles 256 or 57 of the Constitution. The third thing, they also consider bills that divide the national revenue between the national and county government. For example, the Division of Revenue Bill under Article 218 of the Constitution. This is also known as vertical sharing. It also considers bills that divide the national revenue allocated to the county level of government through the Division of Revenue Bill again amongst the county government. For example, the County Allocation of Revenue Bill under Article 218B of the Constitution is also known as horizontal sharing.
So we'll look at the second function of the Senate, which is the allocation of revenue. And they have three roles, which is the division of revenue between the national and the county governments, which, as was said, was vertical allocation. We have the second one, which is county allocation of the revenue bill, which is horizontal allocation. And we have third, which is the review of any bills dealing with the sharing of revenue or any financial matters that concern the county governments. So we look at the first role, which is the division of revenue, the vertical allocation. And under the Article 217 of the Constitution, it mandates that the Senate can determine the basis of allocating the share of revenue to counties annually. And this is actually done every 5 years. And that is actually noted in Article 203, saying that no less than 15% of all revenue collected by the national government should be given to counties. So what does the Senate do in this particular role? So they consider the provisions based on Article 203, which basically talks about the various conditions of actually allocating revenue between the national government and the county government. And this is where you consider the national interest, you consider the economic disparities, you consider the various inequalities between various regions in the country, let's say, for example, Turkana and Nairobi, for example, those are two very different places in terms of development. So that is what is considered here. The second part is the request and consider recommendations from the Commission of Revenue Allocation. So in brief, it actually covers the Equalization Fund, which is all about dealing with those disparities between regions in the country. C, the third part, is they consult the county governments, the county governors, the cabinet secretary responsible of finance, and any organization of county governments. And the last one is that they invite the public, which includes professional bodies, to make submissions on any matters dealing with the vertical allocation of revenue.
The county allocation of revenue. Yes. The Senate is charged with is considering, deliberating, and voting for county allocation as per Article 217 of the Constitution. Next. It considers recommendation made by Commission of Revenue Allocation regarding provisions of any bill as per Article 205, which mentions the same in Chapter 12 of the Public Finance. Next.
So I'm going to take you through impeachment, and the Senate takes a pivotal role in impeachment of the following: the president, the deputy president, the speaker and the deputy speaker, and the governors as well. The next slide. So under the president, the process is outlined in Article 145 of the Constitution, which states that a motion for the impeachment of the president may be passed on the ground of a gross violation of the Constitution or any other law, or where there are serious reasons for believing that the president has committed a crime under national or international law, or for gross misconduct. And the Senate is required to investigate allegations for impeachment of the president and resolve if they have been substantiated. If the Senate may build up a committee of 11 senators to investigate these allegations, and if the allegations have been authenticated, then the Senate shall accord the president an opportunity to be heard and vote on the impeachment charges. And if at least 2/3 of all senators vote to uphold an impeachment charge, the president will cease to hold office. Next slide. Under the deputy president, the process is outlined in Article 150 of the Constitution, which has the same, it's been outlined kind of similar to the president, whereby a motion can be moved for impeachment of the deputy president on the ground of a gross violation of a provision of the Constitution or of any other law, for gross misconduct, or where there are serious reasons for believing that the president has committed a crime under national or international law. The Senate is required to investigate allegations for impeachment of the deputy president and resolve if they have been substantiated. The Senate may appoint a special committee of 11 senators to investigate the allegations, and if it finds that the allegations have been substantiated, then the Senate can accord the deputy president an opportunity to be heard and vote on the impeachment charges. And if at least 2/3 of all senators vote to uphold the impeachment charge, the deputy president will cease to hold office.
If you can go to the next slide, I'm going to take you through how the procedure of the Senate to impeaching the Speaker or the Deputy Speaker. So under Article 106, it gives the Senate power to remove the Speaker or the Deputy Speaker if it passes a resolution supported by at least 2/3 of its members. Move on to the next slide. So for governors, the process of impeachment is outlined in Article 181 of the Constitution and Section 33 of the County Governments Act. The Senate is required to investigate allegations for impeachment of the governor and resolve if they have been substantiated. The Senate may appoint a special committee of 11 senators to investigate the allegations. If the special committee of the Senate or the Senate sitting in plenary finds that the allegations have been substantiated, then the Senate shall, number one, accord the governor an opportunity to be heard and vote on the impeachment of charges. This is, for example, what happened to Governor Igoro when she was being impeached. If the majority of senators vote to uphold the impeachment charge, the governor ceases to hold office. And if the vote to impeach fails, the Speaker of the Senate shall inform the Speaker of the concerned county assembly. Thank you.
So, qualifications for the position of a senator in Kenya. Any candidate who's intending to become a senator in Kenya has to meet a certain threshold that is stipulated by the IEBC. So the IEBC provides the following guidelines for people who want to.
Class, 1 more minute.
So one has to be a Kenyan citizen of at least 10 years before the election, not hold dual citizenship. The person must also not owe allegiance to a foreign state. They should be a registered voter and be nominated by a political party or as an independent candidate.
So the next one is they should follow the chapter 6 that they should not have been found to have abused or misused public office, which clearly states that in chapter 6, which is on the topic of leadership and integrity. So the next one is to not have been dismissed or removed from public office, contravening the provisions of Article 75. Article 75 talks about the conduct of state officers. Article 76, which is the financial probity of state officers.
You copy Eliza?
Yeah. And they should have a sound mind. Thank you.
Okay. Oh, sorry. Thank you so much, group number 6. That was also a very good presentation. You have really explained well the lawmaking function of the Senate, and I want to query you a little bit on that. When it comes to the lawmaking function of the Senate, Philip, please explain to me what is so special about how does the Senate participate in lawmaking? How does the Senate participate in lawmaking at the national level, at the national government? Philip?
Yes. I'm not sure. Do I read the slides again or?
No. Just explain them. You don't have to put up the slides again.
So the Senate, as you said, the Senate considers, debates, and approves bills. So once a bill is tabled in the national government, the Senate in the National Assembly, the Senate gets to approve the bill, and they can also table the bill themselves.
Mm-hmm. Yeah. There we go. Philip, not quite. So what kind of bills are these?
Here is the mechanism. I can see the motor. Bills either concerning powers of the county governments, bills about the finances of the county government. Recently they defined the sharing of funds to counties.
Okay. All right, Philip. Because of time, let me not take it a bit further. But thank you, group number 6. Let's move to group 7. I'll call the members to confirm who is present. Check it out. George Kimtai.
Present.
Regan. Regan.
Present.
Brian.
Present.
Ian.
Yeah.
Austin. Absent. Okay, at least here one member is absent. It's always problematic when a student is absent from a presentation. Now they have to do a sitting. Onyoni. Brian.
I'm here.
Rodney. Bakari. Shadrach. Okay. Edward.
Present.
Orina.
Present.
All right. So just two people who are absent. We have Rodney Bakari, who is absent, and Austin, who is also absent. Please continue the presentation.
So I will be introducing group 7. We're supposed to cover the executive, the mandates, the functions, and the composition of the executive. So we can go to the first slide. So on the introduction of the executive is charged with enforcing the law. The executive branch consists of the president, the deputy president, the cabinet secretaries as a whole, and the attorney general. The DPP, in a nutshell. The composition of the executive, I think I've already mentioned. It kind of reflects on the region, the ethnic diversity, and the whole people of Kenya. So, as I've mentioned, they help in enforcing laws. They do not set the laws, or neither do they review the laws. So, I'm going to invite my group mates to talk about the mandate of the executive.
Okay, for the mandate of the executive, it basically talks about the authority granted to the executive, which in their case, it mainly handles the enforcement of laws. So for the members of the executive, next slide. So for the first member of the executive is the president. He is the head of state and head of the government. So he or she exercises the executive authority.
Presentation on slideshow mode. Please put it on slideshow mode so that it's clearer. Yeah, present. Click present.
It's my ass kicking outfit, bitch.
Continue because of time.
Okay, he or she exercises the executive authority of the republic.
The presenter put this slide on slideshow mode. Ian Kaneman, put it on slideshow mode. It's there. Just click on slide present.
Absolutely.
Ian, are you there? Ian.
We're talking away. I don't know
Okay.
what I'm saying.
All right.
On my laptop just hung. Sorry about that.
We'll go to the president. Okay. He or she exercises the authority of the Republic with the assistance of the Deputy President and the Cabinet Secretaries. These are some of the functions that he or she is entitled to perform. Addressing the opening of each newly elected parliament, the President shall nominate the Cabinet Secretaries, Attorney General, Secretary of the Cabinet, and Principal Secretaries. He is also has the responsibility of chairing cabinet meetings, receiving national diplomats and consular representatives of other countries, and declaring war with the approval of parliament. Next. For the mandates or the authorities that the president is granted includes he or she is the commander-in-chief of the Kenya Defense Forces, is the chairperson of the National Security Council, he's the head of state and national government, he's a symbol of national unity, and he exercises the executive authority of the republic with the assistance of the deputy president and the cabinet. Next.
So I'll be taking you through the functions of the deputy president. The DP is elected by the people alongside the president every 5 years and is the principal assistant who deputizes all the presidential roles. He or she is also put in charge of national projects that are spearheaded by the president himself. He is responsible for taking over the presidential role in case of temporary or permanent absence of the president. Unlike in other African countries, the presidency is not allowed to hold any other public office.
I'll be taking you through the cabinet. So the cabinet consists of the president, the deputy, the attorney general, and between 14 and 22 cabinet secretaries, since there are only 22 ministries in the country. A decision by the cabinet is usually in writing, and the cabinet secretaries are accountable individually and collectively as a whole to the president for their duties and to exercise the power and performance of their functions. A cabinet secretary is not a member of the parliament and has to be vetted by the parliamentary committee before the appointment. Vetting just means background checks and all of that. So functions of the cabinet include to formulate national and foreign policies to guide the country, to advise the president on issues of national developments related to their respective ministries, to initiate government bills for discussion in parliament, to discuss important national and international issues, and to defend government policies. So if you want to become a cabinet secretary, you must be nominated by the president with approval of the National Assembly. You cannot be a member of the Kenyan Parliament, and you have to be vetted by a parliamentary committee, as I've said before. The candidate must have academic credentials, professional training in the related field, meaning you have to have gone to university or school, and you have to be an expert in your field. You also must have experience in working in the government or the private sector. You must have demonstrated trust and loyalty to presidents and prime ministers before you can be appointed into the position. And you should be able to represent the country and the country's citizens together with their interests. So some examples of cabinet secretaries are Fred Matiang'i and the group.
The chapter where Hanma Ujiro challenged the prehistoric man in a battle of strength. Do you think the prehistoric strength of Pickle can surpass the strongest man alive? Let's find out. But first, please know that
Finished.
we have a new Grappler Baki volume collection. Baki the Grappler Season 1 and 2 DVDs, and Bandai's Grappler Baki.
So I'm going to take you through the Attorney General. So the current Attorney General.
Please subscribe and let's begin. The chapter starts inside the U.S. facility.
Please take the
So,
presentation to the Attorney General.
Same. Pickle. So they named already a warrior that existed.
so I just go ahead.
And it's almost
So the current Attorney General of Kenya is one Paul Kariuki Kihara, and he has been appointed since February 2018 by the president. So for the Attorney General,
Ayan, move the slides to the Attorney General. Can we have the slides in tune with whatever the scheme the speaker is speaking about? Or else the slides will have no relevance.
the Attorney General is the principal legal advisor to the government. So he's nominated, first nomination by the president, and then approved. The nomination is approved by the National Assembly, and then is appointed permanently. So the qualifications for the Attorney General is the same as the ones for the Chief Justice, and some of the roles include representing the national government in court or in any other legal proceedings that the national government is part of. Another function, another approach rather, is that you perform other functions that are conferred on the office by an act of parliament or by the president. The Attorney General also has the authority to, with the leave of court, to appear as friend of the court in any proceedings for the government or just as a party. And he promotes, protects, and upholds the rule of law and also defends the public interest. So these powers can be exercised in person or can be delegated to subordinate officers according to the general or special instructions. So I think that's it. So the next slide.
So for the Director of Public Prosecutions, the current Director of Public Prosecution is Nadine Haji, who was nominated and approved by the National Assembly and appointed by the President. So the Director of Public Prosecutions is the head of the Office of the Director of Public Prosecution and operates independently according to Article 157 of the Constitution. So the core functions of the Office of the DPP include prosecution of those charged by the police and other investigative agencies with criminal offenses, while upholding, protecting, and promoting human and constitutional rights. They also advise government ministries, departments, and state corporations on matters pertaining to the application of criminal law. Yeah, thank you. That's all.
Thank you for that presentation. But the DPP, who said that? Why are you putting the DPP in that mix? He's not a member of the executive. The DPP is not a member of the executive. Please note that the DPP's office is an independent office, not part of the parliament, not part of the executive, not part of the. Okay, it works with the judiciary, but as an independent office to prosecute criminal matters. So including DPP there is incorrect. DPP is not part of the cabinet. The executive, and even the Attorney General is an ex officio member of the cabinet. He's not really a part of the executive, simply an ex officio member of the cabinet. As an ex officio member, the AG looks into ensuring that the government follows the law. So the AG is the principal legal advisor of the government. So he only sits in cabinet meetings on that capacity. And I think he also can act as the secretary of the cabinet, of those cabinet meetings. So just one or two questions to the group before we move to the next group.
Pickle is a living national treasure. Please don't hurt.
Okay, so perhaps I should start.
I also have a request.
Onyoni, please explain to us at least two functions of the cabinet, two key functions of the cabinet.
Destruction or theft. Just like me, they just wanted to pay their respect to Pickle and welcome them. But if you refuse, it's okay.
Onyoni, explain. Okay, there you are. Sorry.
A hell of a lot of fun
They create foreign policies for guiding the country, and
They also discuss important national and international issues to do with the country. With
Like,
respect to the ministries. So for instance, if they're discussing about the direction of education in the country, they're usually the ones who come up with the ideas before they pass it into parliament.
okay.
I'm going to share with you
Uh,
massively more disturbing stories, and at the end of each of them, I'm going to share with
ideas
you a
before they
video
pass
that's
the ideas to
famously
parliament.
associated with them. But before
What
we get into today's stories, if you're a fan of these strange, dark,
what kind of ideas are these that they're passing to parliament?
and you
Please
come
be
to our channel
specific.
because
General
that's all I
statements will
do,
not get us anywhere.
4 even 5 times
Government build.
to you, please offer to make the like button
Government
peanut butter and jelly.
Build.
bill. Which
Yes.
bills? Like the bill that is made a draft law, or which kind of bill are you talking about here?
I'm not very sure, but typically they usually
Socially weak people as people.
bills they pass. It's usually with respect to the office. For instance, if they want to pass a bill to do with energy in the energy sector, like they want to.
No. The executive does not. Onyoni, where did you get the impression that the executive passes bills?
Oh, I'm talking about the cabinet.
Or the cabinet doesn't. It's the executive. The cabinet is part of the executive. It doesn't pass any bills.
Oh.
Honestly, I never
That is
thought this would
incorrect.
happen, but throughout the months of us writing,
So,
something just happened.
the executive, it's the parliament that passes bill. A bill is a draft law, in case you're talking about bill of BILL.
Relationship will bring.
Brian Maunda, please come to the aid of Onyoni and clarify whether the cabinet participates in any way in the lawmaking process. Brian, does the cabinet participate in any way in the lawmaking process?
Yep. Can you repeat the question?
Does the executive participate in any way in the lawmaking process in Kenya?
Not to my knowledge. I think that their main duty is to simply to just pass the laws.
Whose main duty is to pass the law? Hey, I'm going to deduct one mark from this group. Elisa? Okay,
To enforce the executive's main work is to enforce the laws. That's what I know.
Not to pass the laws, Brian, because I will have deducted 2 marks from your group when I eventually decide on the mark I'm going to award you. How can you say that the role of the executive is to pass laws? Brian,
yeah.
I hope that was a mistake. You've said you meant what? To enforce?
Yeah, it was just a slip of the tongue.
Okay, yeah, to enforce laws. Although the president does play a role. He's the one who assents to bills. So he assents. The president has a function he plays to make laws. He assents to the bill. So he assents to the bill. And thank you, group number 7. Also very good. I think you guys have done well. You know what you're talking about. At least no one is off on a very rough tangent. There are good ideas there. Which brings us to group number 8, Chemjor.
When I was working at a TTY job in my younger days, a customer was upset that he had to wait in line like everyone else before being able to make his purchase. He actually said, "Do you know who I am? I own hotels." To which I replied,
Roseanne.
"Well, sir, I'm sorry, but this isn't Monopoly.
Amani.
This is Krispy Kreme." He was not pleased.
Isaac.
When to go get my exhaust fixed.
Thomas.
No big deal, pothole, poked a hole in it.
Okay, Hassan.
When I went to go pick up the car a couple hours later, I am treated to a woman
Maureen.
screaming at the guy behind the counter. She's
Present.
foaming because she has been waiting nearly 30 minutes for her car to be
Present.
fixed. She even goes
All right,
so
please
far as
start
to
group
call the
8.
guy an insignificant, lazy immigrant. Guy looks at her, looks at me, throws me my keys. Here you go. Your Magnum's ready, no charge. Looks her directly in the eyes. Looks like it's going to be more expensive than we originally thought. Would you like us to call you a cab? I returned shortly afterwards with pizza for the shop. TLDR. FCK bitches. I watched a lazy shopper park their grocery cart right behind another person's car instead of putting it in the cart return. I got out of my car, ran up and moved the cart and put it behind her car. I then ran off and watched her have to get back out of her car since she couldn't back out. And then finally proceed to put up the cart
Can you all
the
see the
right way.
screen?
I felt like a champion of the people.
Yeah.
I was at a Walmart and a lady got in her car, rolled down her window and started throwing
Okay.
papers out.
So these are the group members. We're dealing with the county assembly. So Article 176 of the Constitution established the county government, which now consists of the county assembly and the county executive. Now, county assembly is basically the lawmaking organ of the county government. We can start off by looking at the composition of the county assembly. First of all, we have the elected members. Now, the elected members represent each particular ward in the county assembly, and they are elected by the registered voters of a particular county. And however, the minimum number of elected members in a particular county has been set to 15 by the IEBC. Next, we have nominated members, which are split into two categories: special seat members and members of the marginalized groups. Now, special seat members are nominated by political parties after the elections, and they are meant to provide a gender role in that to ensure not more than 2/3 of the members is of the same gender. Although currently there is a bill that is being challenged, there's a bill that states that they are trying to remove this, in that we can have women members for at least 3 wards. Yeah. Also, we have members of marginalized groups, who are 6, maximum of 6, nominated by the political parties, and they represent persons with disabilities, the youth, and marginalized groups. Lastly, we have the Speaker of the National Assembly, of the County Assembly. The Speaker is the ex officio member, and he chairs all proceedings of the County Assembly. And in the case where the Speaker is not available, or the County Assembly are discussing matters that directly affect the Speaker, there is usually somehow like a deputy speaker who is elected from among the members that will preside over all the sittings for the lifespan of the county assembly. Next, we can have someone check through the mandate and functions.
The mandate and functions of the county assembly. This is the work of the county assembly in the county government as defined in the Constitution of Kenya. You should note that they evolve with time because they grow to encompass other wide aspects that are not codified before. So the roles include to be home and executor of legislative authority of the county assembly by making and unmaking laws, approving county government development plans and budgets, among other things. Okay, next. They also perform an oversight role, an oversight role that ensures the achievements of objectives of the devolution are met. This can be done through promoting democratic and accountable exercise of power, fostering national unity by recognition of diversity, among other things. So they also ensure the efficiency and effectiveness of service delivery. They make reports and recommendations on various county government projects and policies. They ensure the needs and priorities of residents are met. And they also hold the county executive accountable to the implementation of its policies. So these actions are performed through the county assembly departmental or sectoral committees that scrutinize the activities and policies. The activities, policies, and programs of the county government. They also conduct investigation on issues and projects of the county, and they also provide opportunity for public input and experts on particular subjects. The whole house summons and questions the county executive committee on special issues.
Maybe you shouldn't have parked it in a handicap spot and drove off.
So another mandate is
I
that they
work in a
receive the
university
deliveries.
computer lab.
They receive the
In all of the
deliveries
lab
for
rooms, we have
approval.
it clearly posted.
1. All development plans,
No
programs,
drinks.
policies, and budgets
I've
for
repeatedly
county
told a
government.
particular group that is in the journalism
2.
program
After
to at
vetting all
least clean
nominees,
up their mess in the
they
lab
they
room
also vet
designated for
nominees
their
for
class
appointment
only.
as
They never
county
do, and I end up
secretary
cleaning the mess.
and chief of
The other
staff.
night I go to lock up that
3. They
particular lab
borrow
room and they
a
have left a
county
mess of Fox
government
News running on the
in
TV
accordance with
there.
provisions of
Just went ahead and put a channel
that
lock with
section.
passcode on it the night before election day.
The 4th one, appointment of a
By
clerk
watching their face after
for
telling
county
them they've
assembly
arrested
on
the day
recommendation
was
of the
pleasant
county
as you
assembly
are.
service board. Next,
Reported a hit and run today. That's pretty
the fourth
good.
one, the
But
fourth
I'm sure they won't
function.
enjoy the
They
call from the
represent the
police.
electorate of a
Not me, but
county
when
in
I
the
was working
government,
at a car
in the
dealership, we had a
government,
bunch of
including
cars get
provision
their
leadership
wheels
in the
stolen
liberation
one
of
night.
all matters
A police officer
concerning
was
an
inviting a
interest.
report, and a lady came in
However,
screaming
members
that
of
the
a
cop was
county
blocking
assembly
her
do
from
not
getting to
get
the
direct
service
involved in
drive-through.
the
She was
executive
screaming at the
functions
top of her
of a
lungs,
county
creating
government
a
or
huge scene.
in the delivery of
The
the
cop
service
calmly
meant to be
walks out
done
and moves his
by the
car,
county
comes
public
back in and
service.
finishes his report. Then he walks back out and drives his car to the end of the street
So
and
we'll talk
parks.
about the
The lady
legislative
comes out
process of
and
a
gets
bill
in
in
her
the
car
county
and
assembly.
leaves.
So
He
a
pulls
bill
her over for
it's
having
a
her
proposed
wipers on without
legislation
her
that needs to be
headlights on.
considered by either
Her
the
wipers on
parliament,
without her
so that's the
headlights
National
on.
Assembly or the
This is
county
illegal.
assembly, then upon approval or sent
Services at a decent
to by the
sized
president or
university.
the governor,
I
it
don't
becomes an
write the
act of
tickets.
parliament.
I just man
So
the
a
front
bill
desk,
concerning a county
answer
government is
questions,
one which
and
affects the
enter
county
permits and
government,
changes into
either
our database.
its
Get your
finances or
custard
the
out.
functions and the powers of the
So it's
county
nothing
government.
new.
So what
But
is the
this bitch
process of
comes
a
and
bill
raising
at the
hell over
county
some tickets
assembly?
she
So the
rightfully
first one
got.
is the
She was being
publication and
so ignorant and
circulation.
ignorant about
This
the
is
whole
where
situation
the bill is
that I
published
politely
in
look
the
up her accounts
county
to
and the
see if
Kenya
I can
Gazette,
find any
and
errors
then
or
which is
anything that
released
might help her.
occasionally. The
She is
second stage is
constantly
the
abusing
first
me the whole
reading.
time
So
I am
the
trying to
intention of the
see what
first
I
reading
can
is
do for
to
her.
draw
Well, look
attention
here.
of the members of the
These
assembly
100
and also
copies
the
of
general
tickets you're
public
complaining
to
about
the
ought to be
bill.
linked to your account
So
for
the
some
third
reason.
step
I don't tell her this, but I
is
do
the
often
second
see her
reading.
last
So
ticket,
in the second
so I
reading, here
can
is
check
where
if
we have
everything
the
is
mover
right.
of the bill
Little does she know,
outlines the main purpose
with
of
the
the bill, and
info,
this is
I
discussed.
got from the
So
ticket I
the members of the
transferred all
assembly
those
discuss the
tickets she
bill
got onto her
and the
account.
views of the mover
If he would
together
have
with
been
the
nice about the
report of the
whole thing,
sectorial
she
committee.
would have probably
And then
gotten away
the only
without ever
amendment that
having to
could be
pay
made
those.
at this stage
Now she
is
has
to
a few
defer its
good bucks
second
worth
reading
of
for 6
tickets.
months. Then the
I
fourth
think I
stage
actually
is the
made a rude
committee of
person's
the
day
whole
better
house.
once.
So in
I
this
was at a
stage
pub
is
and
where
he
we
was
discuss the
berating the
bill
waitress
close
about
by
how his
close,
neighbor had
and
something on
we
his
members
menu
may propose
requested
any
left off or
amendments,
something.
but no
Kind of
amendment
made me
is
sick.
permitted if it
So
changes
I
the
turned
direct,
around
the
and
main
asked him
purpose
if
of
that was
the
really
objective
necessary.
of the bill.
And to my
Then we
surprise, he
have the report
apologized to the
stage.
waitress,
So in the report stage
told her
is
how
where we
things
have the
hadn't been going
sectorial
right.
committee
But that's no
informing the
excuse for
assembly
his actions,
sitting
yada,
of the
yada, yada.
considerations of the
Once she
bill.
left to
Then we
fix his
have the
order, I
final
asked him
stage,
if
which
he
is the
wanted to
third
vent.
reading.
He
Here is
went on
where the
for about
members
3
debate
minutes
on
just
the
ranting, and
principles of
afterwards he
the
thanked me. He
bill,
said if
and
so
then further
it's bad
amendments
if he
can't be
enjoyed
made
his
at this
meal.
point
For
except to
everyone who
defer
acts like an ass
the
wants
third
to be an
reading
ass
for
all the
6
time.
months.
People have bad days, and
So after
sometimes
a
they take it
bill,
out on others.
after a bill is
It's
passed,
not
it
good,
has to be
but I
assented.
tend to wait
Sorry,
to judge someone
assented
until
by
I
the
have at least a
governor,
few
and a bill
interactions with
is
them.
only becomes law
In
once it has
France,
been
I speak
published.
Dutch.
And then before a governor
So
actually
I work at
assents
a
to a
pretty
bill, he has to
multicultural, and
ensure
they're
that the
doing some
bill
volunteer work,
upholds
and
the
I was
values and the
buddy.
principles that
We
are
in the constitution, and also that the bill that is being passed and proposed is capable of implementation.
One of these girls and started making his move. Nice and slow and all that.
So next, we're going to have the seasons in the life of a county assembly. There are 7 different segments beginning from the time it was first sworn in, following general election to its dissolution. So the first we're going to look at is the county assembly, which was established in accordance with the provisions of section 177 and 178 of the Constitution of Kenya 2010, which basically talks about the membership and of a county assembly and the speaker of a county assembly. Next slide, please. The second we're going to look at is a session of a county assembly, whereby the county governor conveys the first session through a gazette, which basically specifies the place and date of the sitting, and it is basically issued within 30 days after declaration of the results of the general election. Then we have a regular session, which is convened by the Honorable Speaker in each year, commencing the second Tuesday in February, and or on a date set by a resolution of the county assembly. Also, the duration of a regular session is specified in its calendar, and then it's ended by adjournment on the date specified in the calendar or dissolved upon expiry of its statutory form term. In the fifth year, in the fifth year of the life of a county assembly, the dissolution would pave way for a general election. Then we have a sitting of a county assembly. A sitting can be defined as each of the days of a county assembly meets as a plenary or a committee of the whole county assembly or a select committee based on a calendar of a county assembly. The sittings are regulated by standing orders, and the definition of a sitting can vary based on the business to be transacted. The adjournments of the intervals between adjournments are basically the intervals between sets of meetings in session.
It wasn't a big club, so I walked over and
So I'm going to take you through the next session segment. So prorogation of a county assembly. This is basically means that a parliamentary session has been ended or discontinued until the period when the next session starts. In this case, if there was any pending business before a county assembly halts or stops, the relevant standing orders will be applied in order to see the best course of action. Next slide. Okay, dissolution of a county assembly. This usually happens in the fifth year of its life. It basically marks the end of its term before a new county assembly is elected. This always goes in line with when the general election was conducted and from the first time they got into office. Next slide. Adjournment of a county assembly. This is an interruption that occurs between sittings, but it always occurs in accordance to the standing orders. And there are various forms of adjournment depending on the causes or reasons, though predictability does emerge in practice. Next slide, thank you. Then recess of a county assembly. Recess is the period when the county assembly is adjourned to a day that is not the normal sitting day. Moreover, we should also note that a recess at the end of a county assembly's life is not as important as it will have already been dissolved.
Demanding a manager.
Okay, so the recall of members of county assembly, popularly known as the MCA. So according to the County Government Act, there are requirements and procedures for recalling an MCA. So a member of county assembly may be recalled.
Two more minutes.
Okay, so they're recalled if they violated the provisions of Chapter 6, which is on leadership of the Constitution, and if they've mismanaged public resources, and if they're convicted of offences, and they can only be recalled if the High Court actually confirms that the grounds I've specified were broken, and it can be initiated only 24 months after the election.
That's very clear.
Slide. Okay. Yeah, basically. Next.
By the time she gets to the front, she's yelling at me for making her miss
okay,
the
so the County Assembly Service Board is basically like the human resources wing of the County Assembly, and it comprises of five main members. You have the Speaker, who's the chair, the vice chair, who's any of the two other members. Two of the members are known as non-members. They are members who are actually nominated by the political parties they represent, and Then we have one woman and one man appointed by the county assembly from people who are experienced in public affairs as well. Next, so the county assembly has 5 main roles in section 12, as outlined in section 12. It provides services and facilities to ensure effective functioning of the county assembly. It constitutes, it prepares annual estimates of expenditure of the county assembly, undertakes singly or jointly with other relevant organizations and programs to promote the ideals of democracy. And it also has some other subordinate functions, which are outlined in the next slide. So the subordinate functions of the county, the CSAB, are to direct and supervise the administration of the services and facilities.
Prostitutes and the drug addicts congregated. I bet they glazed his donut. Waiting in line to vote today, I stood next to an Asian
determine and review the terms and conditions of this to initiate harmonized
elections.
Yes.
Struck me as a very well-educated person.
Finish up, wrap up.
About this election season.
To initiate, coordinate, and harmonize the policies and strategies relating to the development of the service, and to initiate programs such as training, programs that facilitate, that promote the ideals of the democracy as outlined in Article 127, and to do other things that may be necessary for the well-being of the members and staff of the county assembly.
Vested in me by the MTA and the borough of Manhattan.
So according to Article 235 of the Constitution of Kenya, the County Public Service Board originates from that because it states that every county should have its own public service, known as the County Public Service. So that the members of
sorry. Yeah, your time is up.
Seventh grade jackouts, guys, don't let difficulties
Go to the last slide.
get either way of doling out tea. So the head asshole. Who was this fat? Completely cruel to the kid was being a dick to her right in front of me and a few.
This is the last slide is functions of the
so naturally
county public service.
Mothefka in the stomach. He got the wind knocked out of him a little. But I didn't actually hurt him.
I'll ask you a question or two as we allow for the other group to set up their presentation. Time is fast spent.
The little man goes
so I want to ask Hassan Khaltoum, please clarify the difference between what's the difference, if any, between recess of a county assembly and dissolution of a county assembly. What is the difference between those two? Recess and dissolution?
A recess is a break. Dissolution is when it's coming to the end of the life of a county assembly.
Okay, correct. Thanks, Hassan. All right, thank you so much, group number 8. Unfortunately, that is the only question I'll ask you. Even though I wanted to ask more, I will invite group number 9. Audrey?
Present.
Audrey, present, okay. Gabriel?
Present.
Marvin?
Present.
Ian?
Present.
Eric?
Present.
Michelle?
Present.
Fiona?
Present.
Absent. Oh.
Present.
Naomi?
Present.
Ezekiel?
Present.
Kevin?
Present.
Okay. So it seems all members of group 9 are present. Please, 15 minutes. Start.
The Constitution bestows the executive authority of the county to the County Executive Committee. Let's go ahead and look at the composition of this committee. The County Executive Committee is made up of the governor, the deputy governor, and members who are appointed by the county governor. However, they have to be approved by the county assembly. The picture on the right just gives you how the county executive fits into the bigger picture. More on the governor will be explained by Eric.
Okay, thank you. So I'll be talking about the election of the county governor and the deputy county governor. So as well, it may be public knowledge, but we can just go over. To be eligible for election as a county governor, the person must be eligible for election of the members of the county assembly. Another way that you can be eligible is that you can become a governor is if one candidate for the county governor is nominated before election. That's when that candidate can be declared to be the governor because he doesn't have any competition. If two or more candidates are nominated, an election shall be held within the county. I think most people are familiar with that. Another possibility of when the county governor shall be elected is each candidate for election as a county government shall nominate at least one qualified person as their running mate for deputy county governor. So that's how also a deputy governor can be elected. And another fact is that the IEBC, Independent Electoral Boundaries Commission, is not allowed to conduct any separate election for the deputy governor, since the person who is nominated by the winner, who has become governor, is automatically considered as the deputy governor. So there are some instances where a person cannot hold office, for example, as a county governor or deputy county governor. For example, as a county governor for more than 2 terms, they cannot become a governor again. And also the same is for the deputy governor. So yes, that's mostly about the election of the county governor and the deputy governor. I can hand over to my colleague Gresham to continue the presentation.
Yeah. So the governor appoints the county executive with the approval of the county assembly. So according to the law, it should not exceed a third of the number of the members of the county assembly if the assembly has less than 30 members. And if the county assembly exceeds 30, he can only appoint 10 of the members in the county assembly. Next slide. And also an important point to note is that when the governor seat is declared vacant, the county executive members that he appointed will also lose their jobs as county executives. Okay, so process to impeach a county governor. The constitution allows the parliament to come up with laws to impeach the county governor. And these laws also act as the guide that the Senate will follow to impeach the governors. Next.
I'll be talking about the grounds for the removal of a county governor. So Article 181 of the Constitution provides the grounds for the removal of a county governor. A county governor is removed if there has been a gross violation of the Constitution or any other law, where there are serious reasons to believe that the county governor has committed a crime under the national or international law, abuse of office or gross misconduct, physical or mental incapacity to perform the functions of the office of the county governor. In Kenya, the successful impeachment of Ferdinand Waititu as Kiambu governor opened the floodgates for the removal of more county governors. Kirinyaga Governor Anne Waiguru fought fiercely in the Senate to save her job and political career. There are at least 6 in line for impeachment. For example, Charity Ngilu, who is the county governor for Kitui. The county assemblies are planning to kick them out over a raft of allegations, including graft, abuse of office, and gross violation of the Constitution, which were stated in the grounds for the removal of a county governor. I will hand over to my colleague Fiona.
So, procedure to impeach a county governor. So, Section 33 of the County Governments Act contains the procedure for removal of a county governor. And the first procedure is the county assembly moves a motion to impeach the county governor. So, a member of the county assembly moves a motion to remove a county governor by notice to the speaker. The member relies on the grounds mentioned in Article 181 by the previous speaker to remove a county governor, and the member must receive the support of at least 2/3 of all the other members to remove the motion. If the motion goes through, then the county assembly speaker informs the speaker of the Senate within 2 days. The information is in form of writing, and this information refers to the county assembly resolution passed to impeach the governor. And during this procedure, the governor continues to perform the functions of the office pending the outcome of the impeachment process. So that was the county assembly in impeachment of the county governor. The next one is the role of the Senate in the impeachment process. The Speaker of the Senate then convenes a meeting of the Senate. The meeting is to hear the charges of the county assembly brought against the governor. The Senate then appoints a special committee comprising of 11 members of it to investigate the matter. So the Senate meeting and the appointment of the previous slide. Yeah. The Senate meeting and the appointment of the special committee should occur within 7 days. That is 7 days from the day the Senate Speaker received the notice of the resolution to impeach the county governor from the county assembly speaker. The 11-member special committee of the Senate should then investigate the matter. The committee should report to the Senate within 10 days. It should report whether it finds proof for the charges that the accuser for the accusations brought against the governor. The governor has the right to appear and to be represented before the committee during the duration of his or her investigation. If the special committee finds no proof against the allegations facing the governor, no further proceedings take place. And if it finds proof, the Senate proceeds to vote on impeachment charges. Yeah. Next, I'll give it to Kiragu.
So, based on what we've heard before, we come to understand that the majority of the county delegations in the Senate vote to uphold. If they vote to uphold the impeachment, the governor will cease to hold office. If the delegation vote is rejected, the impeachment charge will be dropped, and any member of the county assembly can be able to bring up the situation later on after 3 months. So, when you come to the vacancy of the office, according to Article 182 of the Constitution, it is said that if a governor is seen unfit to stand in office, given the given circumstances, the deputy governor will be handed over control. And if the deputy governor is unable to take part or lead as they should, the Senate, the Speaker of the Senate will be given the mantle. And then there will be an election of after 60 days to be able to determine a new governor during the period. Yeah, next slide.
So mandate and function. So a mandate is a kind of civil court order compelling one or more specific persons to perform some act. So it's basically a command that will be given to an official on what they are meant to do. While a function is more of an expectation, like this is what you are meant to do, something one should do. Next. So a mandate. The county executive committee shall determine the organization of the county and its various departments. This includes they can create and change departments alongside their purposes. They can determine the number and nature of the departments at the decentralized units. They can also change other departmental details, such as the department names, and even abolish any department.
I'll go in next. So when establishing and organizing the county executive takes into account the following things: to be responsive of the needs of the local community, This also includes the functions and competencies assigned and the ones that are transferred to the county. They should facilitate a culture of public service and accountability in the county public service. They need to be performance oriented and focused on the objectives of the devolved government. This is set out in Article 174 of the Constitution, which states the objectives like promoting democratic and accountability, exercise of power, among others. They need to ensure that the county departments align their roles and responsibilities with the priorities and objectives set out in the county's policies and plans. And they need to organize its departments and other structures in a flexible way. This is in order to respond to changing priorities and also other circumstances. I'll hand over to the next presenter.
So for the functions, the County Executive Committee does the following. It implements within the county itself the national legislation, and also it also implements to the county itself the county legislation. Basically, what this means is, if, for example, if I was going to use Strathmore as an example, assume that Strathmore was a country and a law is passed by the Strathmore board, and now the different faculties, if we were assuming that there were different counties, those counties have boards. So if a law is passed forth by the Strathmore board itself, the directors and whatnot, that is called national legislation. But if, for example, the faculty, for example, like FIT or law or whatever, passes a rule for the faculty itself, it will affect the faculty itself and not other faculties. So, for example, if Nairobi passes a law for Nairobi, that law is going to be for Nairobi itself, not for other counties. Another function, it manages and coordinates the functions of the county assembly and its department, performs other features conferring on it by the constitution or national legislature. That means by the county executive, whatever is written in the constitution or whatever decisions are made by parliament, its work is to implement the laws that have been made and make sure that it's been followed. Next slide, please. Another function is it prepares proposed laws for the county assembly. And an example of this was the Ward Development Fund. For those who don't know what that is, basically it was a fund that was supposed to enable the different wards within the county to use up the funds that are provided to them. It was also supposed to help finance projects within the various wards in the counties. Lastly, the last function is it provides the county assembly with full and regular reports on matters related to the county. These reports are done on a quarterly basis, and they include the budget implementation reports.
Okay, so in addition to those functions, when we were discussing the sources of law, we said that also parliamentary acts can act as a source of law. So apart from Article 183 of the Constitution, you can also look at Section 36 of the County Government Act of Parliament that I think was passed in 2017. I'm not sure, I think it was 2017. And it outlines extra functions for the County Executive Committee, which include perform any other functions conferred to it by the Constitution or the national legislation, to supervise the administration and delivery of services and all decentralized units and agencies in the county, since the jurisdiction is within the county, and to carry out any function incidental to any of the assigned functions. And you'll also see from
from the Act, it also adds a note, which is note 2, that says in the performance of its functions, a county executive committee shall have power to determine its own program of activities, and every member of the committee shall observe integrity and disclosure of interests in any matter before the committee. So that's just part of the Section 36 of the County Government Act. So any questions? Next slide. Do you have any questions?
Thank you. Thank you so much, group number 9. I can see there are so many people messaging me until they're taking my attention away from your presentation. Please, unless you have something relevant to tell me, don't text me, okay? Because I need to listen to other people's presentation. It's unfair. There are students who are quite, once they are presented, now they become impatient on other people's presentation.
Can we talk about those who haven't presented?
My class, eh?
Let's talk about those who haven't presented and they have to give 1.5 hours of their time into this.
It is not your time you're giving. This time will count towards your attendance. It is not
It's
that
our
you're
time
giving.
at the end of the day. This class is scheduled for 3 hours.
Who is talking first and foremost?
My name is
Who
Victor.
is speaking?
My name is Victor.
Victor, I think, Nini, so I will give you time to state your case. Can you allow me to teach the class, Victor? I will give you time to state your case. But for now, this group has presented. They have not even asked questions, and you're jumping in. Can't you give me a time to deal with this group? And then when we go to the next group, we can address this issue.
Fine.
Yeah, you can't just interject like that in the middle of someone else's presentation. We want to close this presentation, and then we'll see how we move forward. So that was group 9. Okay, group 9, that is a very good presentation as well. I think everyone is really doing well so far. You've spoken of impeachment. I think you have covered a lot of ground in your presentation. You brought out the functions of the county executive. Now, what question can I ask you? I'm sorry, my train of thought is disrupted by the many messages I have to reply to. Please don't message me. Don't let me focus on the presentation that is going on, because it is important I give every student due attention. So I will ask who? Michelle Omondi. This question is addressed to you. When it comes to the deputy governor, can that role be done away with? Yeah. The role of a deputy governor, as is the case with Nairobi County, which has not had a deputy governor for so long. So is that role of a deputy government important? And if it is, why?
Okay, in this case, personally, I know why Sonko did not nominate a deputy governor, but it's essential because they help out. And in case the county governor is impeached, the deputy governor. Pardon?
Go proceed. Sorry for interrupting.
And in case the governor is impeached, the county governor can hold up the office so that the other county executive members don't lose their positions.
Okay, sure. So that
can I answered it.
But Lini, I want you to answer it using the functions of the county governor. I want you to the deputy governor. I want you to bring out the functions of the deputy governor under the constitution, apart from just the fact that the governor can die or get impeached. What other important function does the law give to a deputy governor? Michelle?
A governor oversees what is occurring in the county. Yes.
That is too broad. Let me try someone else. I don't want broad answers. I want specific pinpoint answers. That the deputy governor does ABCD under the law. I don't like those general responses that can fit in any shoes. I want a response that can fit in a deputy governor's shoes only.
The deputy governor assists governor and to implement the national legislation that has been put across the country. They also manage and coordinate the functions of the county administration and its departments, and they perform any other functions conferred on it by the constitution. And they also propose laws. Yes.
Okay, good trial. Thank you, group number 9. We will move to group 10. Let's quickly move to group 10 because and then we can now come to the issue of those who feel like, if you want to leave the class, I cannot force you to stay, but at least each group must present. It is an exam session. Exams comes in different ways. Even me, I've been sitting here since 8 p.m. in the morning. So I will give you a chance to ventilate. I'm not reading any messages from the Nini because you're distracting me from the group. I'm supposed to be following the group discussion as well. So I will not answer to any messages. What I will do is I'm going to allow group 10 to go ahead and present. After group 10 has presented, then I can come back and say, if you have just the pointers I can give right now as we move to group 10, I will call them first and then I can tell you as they set up. Mwai Vivian.
Present.
Okay. Nicholas.
Present.
Julie.
Present.
Sirob. Stephanie.
Present.
Bashir. Bashir Mjidaba.
Present, madam.
Maria.
Present.
Odundo Ian.
Present.
Cosmas.
Here, present.
Tuitoik Solomon.
Present.
How is your second name, your surname pronounced? Tuitok. Megan. Mkosi Megan.
Present. Present.
Wanjiku.
Right here, present.
Okay. So we have all of you present. That's a good thing. So let's give this group a chance, and then I will come and address the issues of Nini, the issues of who can leave, how do you leave if you had another appointment. I will address it after this group has presented because it's 17th at 26, and you also
it's
come
a bit too late. It's a bit too late for some of us.
If you feel it's too late,
address it
I'm
right
not
now.
constrained. Please just leave the class if you don't want to stay, okay? Just log off and go.
Okay, fine.
I don't know why I'm holding you back. As long as when you're presenting, when I call a group to present, if a member is not absent, they will have to do another cut. So if you want to leave, I don't want to hold anyone over. And I don't want anyone distracting my class either.
Okay.
Please, unless raise your hand if you want to speak, and I will decide if I'll give you audience. I can't have students disrupting my class. For now, I'm not giving anyone audience until this group present. If someone wants to leave, they are free to go, okay? Just
It's
log
unfair.
off and go.
It's really unfair because it was not
I told
communicated.
you will not disrupt my class, please.
But you're also
Raise your
disrupting our time to do other things.
Group 10, can we? Group 10?
Hi, good evening. Hi, can you hear me?
I can hear you.
Okay, so I'm Julie Munyui and you're group 10. So you are given the task to present on KIPI, which is the Kenya Industrial Property Institute. So these are the members and I will dive into the introduction. So first of all, we need to understand what KIPI is. So as mentioned earlier, this is the Kenya Industrial Property Institute. It was established in the 2nd of May, 2002. We discovered that it is a government parastatal, which is under the Ministry of Industrialization, Trade and Development. So mainly it's supposed to administer industrial property rights and has some other functions which include provisioning of training on industrial training, provisioning of technological information to the public, inventiveness promotion in Kenya. So as we all know, for any organization, it must have a mission, vision, and some values and motto attached to it. As we all know, mission is something that you want to do. Vision is what you want to achieve in future, and the motto is just what you stand by. So we have the mission for the KIPI is to protect and promote industrial property rights and foster innovation for sustainable development in Kenya. So the vision is to be a world-class institution in administration of IP rights. And the motto is Akili ni Mali. So intellectual property is wealth. So finally, that's it. And we're going to jump into the core values of the KIPI. Thank you. Next.
Okay, so next we're going to the core values. First of all, we have confidentiality. KIPI enforces privacy and confidentiality, thus it protects customer information. Next, it has customer focus, where it focuses on the customer first to enable them to meet their set expectations. Next, innovation, where KIPI continuously works towards an environment that encourages creativity, learning and improvement for efficient service delivery. Then we have integrity, where KIPI strives to uphold honesty, fairness, trust, ethics, and accountability in all institutions, itself included in their activities and decision making. Next slide.
Another core value is professionalism. They promise to maintain high standards and professional competence in deliberation of responsibilities and delivery of services, as well as abiding to professional considerations on the methods, standards, and procedures in their work. Also, they promote teamwork, where they claim to create a unique atmosphere of collaboration, mutual support, and genuine interest in each other's success. They also say that their diverse mixing cultures and experiences provide a variety of perspectives and talents when united, especially through teamwork, and they strengthen their ability to achieve their goals.
Okay, so next you're going to take it through the KIPI Board of Directors, and I welcome the next person. Magak.
I'm sorry, that was supposed to be Ian. Ian, are you here? Or should I continue for you? Hello? Ian? Okay, fine. I'll just go through this the Board of Directors.
Sorry.
First, you'll find the chair. All right, never mind. Continue.
I apologize, I'm having a net connection issues, but yeah, let's go on. So the KIPI has a board of directors, which consists of a chairman. So what happens is the chairman is appointed by the ministry, by the cabinet secretary, from a list that's that contains a list of applicants. So in the first meeting, the cabinet secretary chooses from the list of applicants. So the applicants need to have at least a bachelor degree in law or science, and at least 7 years experience in the field of industry property. And then we have a permanent secretary also that is responsible for matters being related to industrial property, or at least a representative. Then we have a secretary to the National Council for Science and Technology, and Attorney General, or a representative at least in his place. Let's move on with Ian.
Okay. Of the 13 members of the board of directors, we have 8 members who are appointed by the minister. However, they are nominated by various organizations. We have a representative nominated by the Kenya Industrial Research Development Institute. We also have a representative nominated by the Kenya Association of Manufacturers, another one by the Law Society of Kenya, and a representative by the Kenya Medical Research Institute. We will also have a renowned research scientist from the public universities who is also appointed by the minister and will be in charge of education for the time being. There will also be a representative nominated by the Institution of Kenyan Engineers, as well as a representative by the Jua Kali Association.
Sorry, for the last two members of the board of directors, there'll be a chief executive from the Kenya Association of Manufacturers, which should not be confused, as the representative was selected earlier. This member mainly acts as the voice of the manufacturers or other value-adding sectors in the Kenyan economy. So that should not be confused. Then finally is the managing director, who is obviously appointed by the board after they've settled in. And this is basically the face of the company. They are used to enact two acts of what KIPI stands for, which is the Industrial Property Act and the Trademarks Act. Finally, this one's not on the site, but it's good to know that the board of directors will not manage their mandates directly. They will make up some committees in order to do this. So the three main committees they make in order to handle all these mandates, which is the Human Resource and Administration Committee, the Audit Committee, and finally the Financial and General Purpose Committee. Thank you. Next slide.
Okay, I will take you through patents and utility models as elements of intellectual property. So patents is a form of intellectual property that grants owners rights of invention for a period of time, so that no one else without consent can use that idea or invention. So there are basically four types. We have utility patents, design patents, plant patents, and provisional patents. So utility patents and design patents are the most prevalent, with utility patents protecting the methodology of something. So that means how something works. Down there you can see those two bulbs. They're bulbs, but they have a different design and they both work differently. So you could patent them differently using the design patent and utility patent. So the design protects the look, the description, the physical look, how it looks. The fourth, which is the provisional patent, is part of the utility and design patent that just grants right for a period of time. For instance, if you have not completed your utility design, where you get to describe what your product does or stuff here. And thirdly, we have the plant patents. So this protects new plants, quote unquote. And please note that you cannot patent just plants. Any type of plant, like a bean, where you get a bean and then you patent it. But if you graft some plants, that can be considered as new, quote unquote, like apple trees. So you can patent that. And let's face it, if you talk of plants, you have to also talk of animals. So I can pose a question where, do you think we can patent dog breeds or dogs, where you can crossbreed dogs and then you patent them? So the answer is no, but you can patent genetically modified animals, like an oncomouse, which is a Harvard mouse, which was developed in the 1980s for use in cancer treatments. Cancer study. Next, please. Moving on to utility models. So utility model is also a statutory rights that gives the holder exclusive rights to some invention. But the exception here is the owner has to disclose everything, the workings of the invention, to someone else to enable them to come up with something of the sort. So these are minor, and in most countries are called petty or small patents. Okay, there are four types where you can get to have a utility model of a manufacture, of a machine, of a process, or an improvement of an idea, of an existing idea. So for manufacture, you can probably manufacture some new thing, that has never been seen, you can patent that. Or a machine, or probably a process of maybe mathematical process or something, or improvement of an idea. So I'm going to leave you with some case of Vermont Flowers versus Waridi Creations. So Vermont Flowers is a Belgian company, whereas Waridi Creations is a Kenyan company. So these employees who are working in Vermont came back to Kenya and patented some the same thing. So like flowers, Waridi is just flowers. So, and they were trying to export some flowers with the design of Vermont. But the problem is these guys, the Vermont guys, hadn't patented their vases and designs and everything. So these guys walked free. The case was actually dismissed in Court of Law of Kenya. And if you want to confirm, that's the link down there. So that's the importance of actually patenting your stuff. Yeah.
Okay, for industrial designs, according to the Industrial Property Act in 2001, an industrial design is defined as any composition of lines or colors or any three-dimensional form, whether or not associated with lines or colors, provided that such composition or form gives a special appearance to a product of industry or handicraft and can serve as a pattern for a product of industry or handicraft. So to summarize all that, it is only concerned with the outward appearance of articles as defined by their shape, the configuration, pattern, or ornament. Next slide. So the process of registration under the Act is as follows. It only has 3 steps. So the first step is to search. So a search is undertaken to establish whether the design is suitable for registration. That is, if it meets the requirements for registration as explained above, and that there is no exact or similar design already registered. Then the second step is the application. So once the design search is accepted, the application is lodged by completing a standard application form. And then the third step, which is the final step, is advertising. So once the application is received by the registrar will verify the same to ensure that it is in order. So if there is any objections, the objector has about 60 days from the date of the publication of the industrial design to file the objection. If no objection is received within those 60 days, the registrar will proceed to issue the certificate of registration.
So we go to technovations. A technovation is a solution to a specific problem in the field of technology that is proposed by an employee within an enterprise in Kenya for use by that specific enterprise. It relates to activities within the enterprise that were not used before, or the enterprise had not considered the solutions before. So once an employee comes up with a technovation, the Industrial Property Act grants this employee the right to a technovation
Group
certificate.
10, please note that you have 5 minutes. You have 5 minutes. Please spread it around your presentation.
Okay.
Move it forward.
Once a technovation certificate is granted to an employee, this certificate is issued to the employee of the enterprise through a proposal date. The certificate binds the technovator to his technovation, his or her technovation, so he has the rights over it. The employee is also granted the right to remuneration. Next slide. This right is granted in the case that the employer uses or communicates the technovation to a third person. There is an example of a case between Samson Gigi versus KRA, where they used his software that he had come up with without his consent. So in the end, KRA was barred from using it or any similar designs to it. Yeah. So Vivian.
Right, next we'll go to trademarks. So a trademark is a sign which basically distinguishes goods of an industrial or commercial enterprise or group of such enterprises. It may consist of letters, works, numbers, drawings of pictures, monograms, signatures, or colors, or many colors, and the trademark could be a combination of all the elements that I've just mentioned. So, according to the Trademarks Act, it describes the mark as a distinguishing guise, slogan, device, brand, heading, label, ticket, name, signature, word, letter, or numeral, or combination of any of these elements, whether rendered in 2 or 3-dimensional form. So, registration of a trademark is used to distinguish exclusive ownership of the mark and keep off infringers who may want to copyright your trademark. Next slide, please. So, a mark similar to a trademark includes service marks, which is just like a trademark, but it's purely for services. The certificate marks, which is used to identify goods that meet either a standard or a certain set of standards. So this mark could be owned by someone, but others could be licensed to identify goods or services which have met the standards. For example, the KEBS mark is a certificate mark, and a distinguishing guise which identifies the unique shape of a product or its package. So, for example, if you have a packet of earbuds whose packaging is in form
Right.
of
2 more minutes, please. 2 more minutes.
of a rabbit, you can make that shape and guide it. Yeah.
Okay, so functions of KIPI. So what they basically do is they administer the industrial property rights. So what this whole organization is basically in charge of like helping you like like give away the rights to your industrial property, which is very unique to your particular company, and then it provides technological information to the public, which means so basically this organization is responsible to provide any trends, for example technology in the documents which were previously mentioned, and then it helps promote inventiveness and innovativeness in Kenya. So that means, so as an organization, they should be they are supposed to like encourage more and more ideas and projects, so that people can even like help them create like job opportunities for the people through those companies. And then it promotes training on industrial property, which is they have like courses and like short like vocational training for the people. And then I'll take you fast, like implement the Trademarks Act, which is the act of the parliament to relate to the registration of the trademarks. And then it screens technology transfer and licenses. So basically, this is when this is a contract used when a company assigns to another like licensee registered industrial and intellectual property rights. So that's what the technology transfer means. And then it institutes infringement proceedings in relation to industrial property rights. So in case like there's been an infringement in the property, like someone has stolen it, so then it can the organization KIPI can help with the procedure to prevent that. And then lastly, the importance of KIPI. So patents offered by the organization help inventors monopolize on the creations and monetize their ideas. So like if let's say if anybody wants to like buy and or use the trademarks, they can then pay whoever is responsible for the trademark and then earn profits accordingly. And then there are also a means of technological.
The last slide. Let's go to the last slide, please.
This is the last slide, madam.
Okay.
Yes,
Last word then. Let's go to the last word.
Okay, as such, they are vital resources for entrepreneurs, researchers, and any academics who need to keep up with development in their fields. So that's basically what KIPI is about. Thank you.
Oh, thank you. Thank you so much. Thank you, group. That is group 10. Group 10 for bringing out the functions of KIPI. Please forgive me because of time. I will not really ask you a question, but I will go straight to group 11. So group 11, Hinga Victor.
Present. Present.
Kivai.
Present.
Bain Fight. Bain Fight.
Present.
Murhula. Please help me pronounce your name. Murhula?
Muhula. Bien fait.
Murhula Bain Fight. Okay. Okoro. Okoro Marvin.
Present. Present.
Munjera.
Present.
Munjera Sharon.
Present.
Habat.
Present.
Habat. Haziz.
Present.
Walter.
Present.
Tyrone.
Present.
Koileken Amos.
Present.
Present. So I know BTC, you're very disadvantaged because you're the ones going to present even much later. But don't worry, tables will be turned. We will have another presentation, and I will start with these last groups. The final groups will be the first ones to start. So today you might be the last, but in our next presentation, which will take almost the same time, I'm not the one who determines the size of the classes. So it will take the same time. Then we can have the BTC start off and the final group start the presentation. So please, you'll have your day. For those who have presented, they feel like they need to go away. As long as the meeting is being recorded, if you want to look at something, you can look. But if you leave and you've not presented, please note that you'll have to do a special exam, and there'll be no argument about that. Because it's just a matter of choice, and studies also take sacrifice. Nothing comes easy. Everything we need to sacrifice for, even our time, as precious as it is. So, with that having been said, I will invite group number 11 to go on with the presentation. Group 11.
Hello. Can you hear me?
No, you're very faint. Please try and speak up, or adjust your recording, your speaker, your mouthpiece.
Can you hear me now?
It's better.
Okay, so our group was going through a repo. Currently, as he opens the slides, I can start. So a repo is African Regional Intellect Property Organization. It is an intergovernmental organization. Basically, there are different regional ones. Like, so this one deals with Africa, but there's also one. It is among different regional organizations. An example being Eurasian Patent Organization that deals with the Eurasian region. It facilitates its main duties are it facilitates cooperation among member states in intellectual property matters, to pool financial and human resources among member states, seek technological advancement for economic, social, technological, scientific, and industrial development. It was established by the Lusaka Agreement of 1976. It officially has 19 members.
Pause there. Can we have the slides? Can we have the slides?
I was sharing the slides. You couldn't see them?
Let's not continue the presentation until we have the slides up.
Can you see the slides right now?
No.
I do.
Wait, let me share them.
Okay.
Okay, so as I was saying, the first slide there.
Yeah.
So as I was saying, it was established by the Lusaka Agreement of 1976. It basically has the capacity for mainly patents and trademarks among its member states, which are defined under protocols, which are defined under protocols. There is the Harare Protocol, which deals with patents, Banjul Protocol, which deals with trademarks, Arusha Protocol, which deals with plant varieties. Next slide, Tyrone. So its mission is to foster creativity and innovation for economic development within Africa, and the vision is for Africa to be a leading intellectual property hub. It officially has 19 member states, the ones which are present on the screen, but there are also observer states. A few among them being Algeria, Angola, Burundi, and Egypt. These are states that can speak at meetings but cannot vote. And the membership is open to all member countries of the Africa. Okay, somebody next will continue.
So I'll going through the organizational structure of ARIPO. So it mainly consists of 4 organs or 4 bodies, which are the Council of Ministers, the Administrative Council, the Boards of Appeal, and the Secretary. The first one being the Council of Ministers is said to be the supreme organ of the organization, and it's majorly responsible for defining, orienting, and guiding the policies of the organization. So it is comprised by Minister of Government of ARIPO member states who are responsible for the administrative and intellectual property law. So for the second one, being the Administrative Council, is the one that recommends the policies to the Council of Ministers and is the one that supervises the implementation of these policies. So it is composed by the head of office responsible for industrial property and copyright in the member state. Its subsidiary committee are under 2 categories. The first one be the technical committee, which had the technical committee of industrial property. This one deal with the patent, the trademark. The second one will being the technical committee of the copyright and related rights, which will be under the copyright. And the third one be the technical committee of plant variety protection. The second category under the administrative council will be the administrative committee, which include the audits, the finance, and the human capital committee. Next slide, please. So the third organ will be the Board of Appeal, which mainly review the appeal against the administrative committee and also review the decision of the Director General. With this, it needs to be an independent organ in order to avoid any misguided. The last one will be the Secretary, which is responsible for the day-to-day activity of the organization. It also implements and executes policies, rule, and procedure then issued by the administrative council and the Council of Ministers. Yeah, the next person can go to this.
Okay, so for the rights covered by ARIPO, we'll start with trademarks. And a trademark is basically a symbol or a word or a combination of both that uniquely identifies goods and services of one producer as being different to another.
Excuse me, can we pass trademark? Can we pass, sorry, just a minute. When you're discussing trademarks, simply discuss the filing system for trademarks. Do not describe what a trademark is, because group 11, group 10 has already discussed that. And then you don't have to take us through the registration process. You can skip that one and go to the part of your slides. Just discuss the regime and the ARIPO within which industrial design is registered, trademarks, and the rest. That will be sufficient.
Okay, so for industrial design, it's under the Harar Protocol. It protects the outward appearance of products by a company. Go to the next slide, please. Okay. Who's presenting on this?
Yeah, can you hear me?
What?
Hello.
We can.
Yes.
Yeah, we can hear you.
Yes, I will take you through the copyright. So a copyright refers to the legal right of the owner of the intellectual property. So the intellectual property that they are referring here, it's the intangible creations. So this refers to the inventions, designs, ideas, and other creations. So copyrights, in a simple meaning, it's a right to copy the work of an author. So copyright law protects back a bit. Yeah. So the copyright law protects original work of authorship. So this means that the original creator of the product and anyone they give authorization to are the only ones with executive right to reproduce the work, which is very important and prevent other people from copying, republishing, or distributing authors' work without their permissions. And next slide. So a copyright generally lasts for the life of the author plus 50 to 70 years after their death. So if someone just tries and break this law for the copyright, so directly they just face large fines, and then they can even be imprisoned. So another thing that you can just know about the copyright is that copyrights are territorial. It's not worldwide copyright law. So each and every country has its own copyright that the country follows. So one of the ARIPO's objective under the Lusaka Agreement, Article 3, is to promote the development of copyright and related right and ensure that the copyright and related right contribute to the economic, social, and cultural development of members and the region as well as a whole. So the copyright and the related work were introduced in the ARIPO mandate in 2002. So the ARIPO strives to develop. Okay. So they are back a bit.
Oh, I think we can go to the copyright section. I think the other part has been discussed by the previous group.
Okay. So what's a patent? A patent is a right granted to an inventor by a government that permits the inventor to exclude others from making, selling, or using the invention for a period of time. So why would I need a patent? I would need a patent if I have an invention with market potential, or if I think another company can profit from my invention. So next slide. This is how in Kenya, which ARIPO is based in, I would get a patent. Number one, I would have to get a request form. Number two, a description of my invention with at least where it will be used. Claim number three, claims defining why you want to protect the invention. Number four, drawings if applicable, and number an abstract that summarizes the invention. Next, I'll look at the inventions that can be patented. For an invention to be patentable, the invention has to be the product of human inventiveness. If something natural happens, let's say a landslide or something like that, and something comes, you can't claim it. The invention must be useful. The invention must be new, not something that hasn't been seen before, and it must not be obvious.
So I'll take in under utility model. So a utility model is an intellectual property title that's also known as a petty patent. It's a patent-like intellectual property that to protect inventions. The type of inventions that are being protected are the ones which an individual modifies an existing device, an appliance, an instrument, handicraft, mechanization, and also products like genetic resources, herbal as well as nutritional formulations, which have practical use and give new effects. Although a utility model is similar to a patent, it is generally less expensive to obtain and maintain and has a short term, generally 6 to 15 years. With a repo, you get 10 years protection. A repo is mandated to register utility model patents on behalf of the Harare Protocol. There's a link below there for more. So, under the traditional knowledge and expression of folklore, there are skills and practices developed and sustained and that are passed from one generation to another within a community, often forming part of the community's culture and spiritual identity. This could be the agricultural way of life, the technical activities, ecological and medicinal knowledge, as well as the biodiversity related to a particular community. So technical knowledge and expression of folklore is unique in the sense that it is not built on scientific and contemporary knowledge. Rather, on experimental knowledge going beyond the spiritual and ritualistic world. ARIPO is mandated under the Swakopmund Protocol on the protection of tradition.
2 more minutes. Mhm.
Yes.
Go to the
2 more
next.
minutes. Although you're talking about something very interesting, please 2 more minutes. If you don't mind.
Okay, so just a couple of key points about the how an application of the intellectual property rights in ARIPO. So you've seen that you can apply for a patent and the traditional knowledge and key traditional knowledge. So with in ARIPO, you can't apply for a copyright application, at least not currently. They plan to include that in the coming, according to the annual report of 2019. So going to the next.
Okay, so I'll take us through this very quickly. So for the Lusaka Agreement, it's basic which happened in 2016. Next. So for the Harare Protocol, where we have the agreement on the patents and intellectual designs, and we also have the examination guidelines for ARIPO. Next, the Banjul Protocol. It's where we have administrative instructions for implementing the Banjul Protocol on marks. That includes trademarks and design. So next, the Swakopmund Protocol basically just deals with the protection of traditional knowledge and folklore of Africa. Yes. Then for the Arusha Protocol, we have it protects the new plant varieties, new plant varieties of plants, and including DNA patterns and grafting. Yeah.
Some recent developments. Number one is that ARIPO partnered with WIPO and OAPI. WIPO is the World Intellectual Property Organization, and OAPI is the Organization of African de la Property Intellectual. Basically, they partnered to promote intellectual property rights across Africa. They met for the following things to do. Number one, it is a joint work lunch to celebrate World IP Day, to discuss developments of IPRs in Africa, joint publications of the African Journal and IPRs, and other periodicals. Other important ones were number one, the contextual study of geographical indicators. Basically, what happens is they want African countries to have indicators of the products they get. You know, let's say you see how the Pope met with the president, where he was presenting with coffee. So that coffee had geographical indicators showing it was coming from Africa. Another thing is on African negotiators. The thing is, with this workshop, it was aimed to address the lack of progress within various norm-setting committees of WIPO due to number one, conflict of interest between developing and developed countries. Also on IP strategy implementation across countries. You want IP strategies that are uniform across countries. Another thing that was discussed is the African Continental Free Trade Area in Africa. Another thing is the collaboration with regional economic communities in Africa. That's Rex.
Thank you so much. I will have to stop you there. Allow the two BTC groups to present. Everyone who is hanging in the class, I really appreciate it. Thank you. I don't take it for granted. I know the class has extended for long, and even me, I am tired. Lakini, let's finish the presentations. It will count through your hours of attending class. So instead of having another extra class, we can always have it counted. So it's not lost time. And I will also set some of these things that are being presented towards the end in the exam, because they are on intellectual properties. You need to understand these bodies. You need to understand KIPI. You need to understand ARIPO. You need to understand WIPO. So the next we're going to is WIPO. So I will stop group number 11 right there. So I want the class representative for BTC. Class representative for BTC, where are you? Mora, are you in class?
Not Mara, I'm Maseno.
No, I can't see you. Maseno, I
Yes.
don't know why. Maseno, just I want to check for the email you sent me with the list of members. Thanks, Maseno, for being with us. Gift Maseno. Gift. Yeah, you totally have a name I can't forget. Though, hey, yeah, quarter says edit. You sent it as a but I will just. Group 1, BTC, very quickly. Cyril Mwaniki Kinubia. This will be group number 12. Cyril, absent. Victor Kimotho.
Present.
Present. Nicole Mokaya.
Present.
Lamek Kibet.
Present.
Michael Mingwi.
Present.
Gift Neema Maseno. I totally like your names. Victor Ongeto.
Yeah.
Absent. Okay. Peter Ukiru.
Yeah, present.
Okay. So please, can we proceed? Don't mind.
Dad, nyamaza. Okay, you can see my screen.
Yeah, we can see your screen, but I don't like how you have said to your dad, Nyamaza. Who has?
Okay, we are going to present on the lawmaking process by the Parliament of Kenya. So one of the key functions is to make laws, and that is attributed to Article 94 of the Constitution through the legislative passing of bills. So a bill can be originated through a parliamentary party. The bill is introduced in the name of the leader, of the majority leader or minority party leader or their respective deputies. Also, it can be originated through the executive, that is introduced in the name of the leader of the majority party or the leader of the minority party in the name of the chairperson of the relevant committee. Individual members of the National Assembly can also introduce bills to the Assembly, or it can be introduced using the Committee of the House.
Neema, what was your question? Remind me. Who is speaking? What was your question?
Let me just. Victor?
What is the issue you're addressing?
The lawmaking
process.
Yes.
In Parliament?
Yes.
Okay. Proceed, please.
Also, a member of the public can petition to the Parliament in provision of Article 119 of the Constitution and standing orders to legislate on a matter that is, a matter that can be passed by the Parliament as a bill. It can be introduced by way of petition conveyed by the Speaker and committed to the relevant departmental committee for consideration and publication of the consequential bill. Also, members of the public may forward legislative proposals to members of parliament who will then issue it as a bill. Lamek?
Okay, we'll take you through the introduction of bills. Give the next slide. So, for a legislative proposal, it must have a sponsor in order for it to be introduced to the House. This means that a member or a committee of the National Assembly will need to have somebody that might budget or sponsor the bill. So a member or committee of the National Assembly wishing to introduce the bill in the House must submit the legislative proposal to the Speaker for approval. The legislative proposal should also be accompanied by the memorandum of objects and reasons, which contains the reason for the bill being proposed, the delegation of legislative powers and limitations of the fundamental rights and freedoms, if any, if the bill might affect any rights and freedoms of the people, and whether the bill will affect the county amends, and if there's a financial implications into the expenditure of the public money, there should be a budget of the bill enacted. Gift, the next slide. Gift. Okay, for the introduction of bills, the memorandum should generally indicate the objectives of the bill. So upon the speaker receiving the bill, from the member of the committee, the speaker asks the clerk to help to aid the person in legislating in creating a proposal document which will have the legitimacy proposal, whether the draft bill of the proposal, and if it's according to the constitution and the law of order. Next. Now somebody else will take us through the types of bills.
Okay, so I think gift you should align the slides because I don't think people are seeing the wordings. Okay.
Yeah,
the types
I
of
thought
bill.
just please let's have that done, eh? Because there's a way I try to fit it on my screen, and I'm wondering what's happening here. Can we have that done? Gift eka slides vizuri.
Okay.
Slideshow. Yeah, that's better.
Yeah, I think that is. So we have said that before a law is made, a bill has to be discussed. It has to be discussed in Parliament. So there are different types of bills. There's a public bill, which proposes a law of general application throughout an area within which it has been passed. There's also a private bill. It is designed to provide a benefit or exemption to an individual or a group from a part of the law directly affecting them or not affecting them. There is also a special bill. This is a bill that affects the functions of a county government and relates to the election of members of a county assembly or a county executive. Yeah, there's also an ordinary bill. This is just basically a bill that is neither a money bill or a special bill. We also have the money bill. It is a bill that contains provisions dealing with taxes, the imposition of charges on a public fund, or the variation or repeal of any of these charges. So as we were discussing, we didn't really work out whether we didn't really work out whether exempting a certain class of individuals from paying taxes, does that apply to a money bill or a private bill? We thought it was a private bill, but it had some monetary implications to it. Yeah, just the next slide. The procedure the procedure for processing proposed bills. Upon receiving the legislative proposal and comments from the clerk, the following process may take place. So if the bill is a money bill, what happens? The speaker refers the proposal to the Budget and Appropriations Committee, which gathers views from different sources, including the Ministry of Finance, which helps the speaker make an informed decision. So you had earlier asked a certain group whether the executive is involved in the law making process, and the decision that was reached was that its work is to oversee. But if you go deep into detail, it also offers an advisory basis for such money bills. The next one is a non-money bill legislative proposal. Such a proposal is sponsored. Such a proposal is sponsored by a committee. The speaker approves. If such a proposal is sponsored by a committee, the speaker approves it. 2. If such a proposal is sponsored by a member, the speaker forwards it to a relevant departmental committee, which then scrutinizes it and gives its recommendation to the speaker. After that, if the speaker approves and accepts a proposal, it is then published. Yeah. So next.
Hello. I'm going to be taking you through the stages of a bill. As you can see through the slides that there are 7 stages of a bill. I'll take you quickly through them. We have the first reading, followed by the second reading, then the committee stage, and then the report stage, and then which is followed by the third reading, then the presidential assent, and then commencement. So we're going to get more into detail. So for the first reading is basically when the bill is introduced in the legislature. So the bill is assigned a tracking number and immediately assigned to a committee. So in Kenya, we mostly follow the British system, which is the Westminster system. The consideration occurs between the second and the third reading. So more information will be given on the second reading. So also on the first reading, we find that it takes place without debate and can take place at any time of the session. So we proceed to the second reading. Next slide.
Okay, so I'm going to discuss the second reading. Second reading is a stage of the legislative process where a draft of the bill is read the second time. It normally happens within 2 weeks after the first reading, and in the Western systems, a vote is taken in the general outlines of the bill before it is sent to the designated committee. And also, you find during the second reading, that's where most amendments are done, and also the second reading deals with the most important legislatives. We can now move to the next stage.
On the committee of the House, the bill is taken to the House and it is considered clause by clause. It gives the members a chance to either propose to amend, but no amendment is permitted if it's a direct negative to what the original proposal of the bill was. The next stage, the next slide, please. The next stage is the report stage. So the committee will inform the assembly of all the changes they have made, but in the report stage. So the chairperson of the committee is the one who's responsible to report the amended bill to the House.
So for the third reading, at this stage, almost all the amendments have been made. So it mostly involves taking a vote by the whole House.
It's still possible for some amendments to be made, but it's unusual and it's rare, as all the amendments have been done in the previous stages. So for bills concerning the county governments, so after the third reading is read, a bill is sent to the Senate for consideration, and then it is passed. It just follows the normal procedure as we've seen earlier, from the first reading to the third reading. It passes through the same stages, and then it may either pass or reject the bill depending on how they view it. Go to the next.
Is Eliana and Craig. And Eliana, you got to give some leeway to because she's in the air most of the time, so her running speed and ground speed is pretty irrelevant. And Craig is a zoner as well as Eliana, so he doesn't really need the movement speed that Forsberg does, because Forsberg is a combo character, or a character with like a combo kit with the movement speed of a zoner, which is terrible and doesn't really make any sense.
Oh, so
More about that.
yeah, at the end of the day, it's the president who gets to decide whether the bill is sent back to the House or it becomes a law. And if he decides that he does not want it to become law and he makes some recommendations, then it gets sent back to the House or the Houses, depending on where the bill came from. If he chooses to accept it as law, then it proceeds on and becomes law.
With the movement speed of the zoner, which is terrible and doesn't really make any sense. And we'll talk more about that as we get
on. Something probably not mentioning is during the third reading, the bill either goes back to the House, the Senate is, or to the National Assembly, depending on where it came from.
Big hindrance because it makes your
And there does exist a mediation committee that comes in between these two houses in the event that a bill is not agreed by any of these houses.
They'll know that your character isn't fast on the ground.
Next slide.
Can at least be more mobile on a platform. He
So
has
this
more options to work
image,
with
I will choose to not go through it because of time, but it basically talks about the process of a bill becoming law.
the platform, so they'll just hit you while you're trying to get there, or they'll cut off your options. They'll put something in the way, like
Thank you. Group number. Group number 12. That is. Well, that was excellent.
Forsberg is going to the platform.
Group 30. Yeah.
His approach is also
Group 30.
because
most
of his approaches are coming from the air. He's almost always going.
But you had the last, group 12 was.
Right, or he's like dash dancing on the platform, waiting for you to overextend so you can fall down.
WIPO. We had a group. We had a group on WIPO.
Right. So
that was group 12. Your group 13. Thanks. So thanks for that presentation on the lawmaking process.
It's very little. That's the second flaw of Forsberg.
It is mini. The presentation is well done. The pictures are. I strongly like the presentation. The picture of the president there assenting to the bill with the signing with his left hand. So thank you for that. I will not ask you questions because of time. I will
I have a question. Sorry, I have a question.
Okay.
What does Fumoto mean?
After this group has presented, I'm so sorry. I have to go to the last group. Hang in there. I will answer your question after this.
Only just holds away.
Diana Abiambo.
Present. Right? You get about 40
Boya.
Only just holds away.
Peter.
Looking really good.
Present.
Michael.
Right? You get about 40 damage.
Present.
And that is essentially the max Forsberg can do.
Yes, sir.
Even at 0, right? The only time, again, when he looks broken is when the opponent
Present.
hold out.
Present. Dennis.
Present.
Alvin.
Right? The only flaw of him is that his edge guarding is not the strongest.
For group number 1, I have 2 people absent. I have Peter Ukiru as absent. I have Cyril Moniki as absent. Taking correct record is very important because everyone who is absent will face consequences of doing another class. So I don't have to argue with someone that's already in class. So I just want to be correct. Please,
that once they reach that 40%,
they were in. They have presented.
You can't do
they have presented.
On them again.
Cyril, where is Cyril? I've not called him.
I presented the second reading.
And they get so far away. And this is
Lukiru presented stages of a bill.
And the heaviest character, so they don't fly.
So all the members of the group are present.
So even Eliana cannot be
Yeah.
hit too often.
Oh
If
no,
he
I will
just
call your
holds
names
out. He's
again.
a
I'm so
character
sorry.
who has
Because
like
I
a
know
lot of
how
like
students collude.
quote
I know
unquote
you love one
combo
another
attacks.
and you
But they only
you'd
really
rather
combo
die with
if the
each other.
opponent gives it to you by holding in. If I pick Sylvanos here, it
So
wouldn't
just to
matter if they
confirm,
were
I
only
want
at
to hear
40%,
who is present.
70%. I'm still going to
Cyril
stop with them
Moniki.
for about 50, 60,
Present.
and Raster, no matter how they hold, until they get to about 80 or 90,
You're present, Cyril.
doesn't care how
Victor
you die,
Kimoto.
he's still going to reach you with his sling,
Present.
right? If the conditions are met, right? If Sling
Lamek
goes out
Kibet.
and they have the execution, yeah,
Present.
you're not getting away from the Raster. Same with Eliana. If they have the execution, you're not
Michael.
getting away from the Eliana. Like if you've seen Sparks clips, if you've seen
Present.
highlight clips, you don't get away from these. Even Gracefight, right? Even though Gracefight is
Gift, I've seen you. Victor Ongeto, I heard you. Peter Ukiru.
Eliana, he still gets the combos regardless
Okay,
of how you die.
let's go to the final group. That will be group number 14.
They're stuck in place.
Group 14.
Gracefight's coming in for that finisher, right? That's how these characters work. You don't get away from them. And the characters that don't work that way, like Sylvanos,
Okay, good evening.
Eliana, right? Who don't just like
No.
regardless of how you die, they have very strong legends.
Pardon, good evening.
Arcane.
We are.
Greg has rocks.
Does anyone wish to interrupt me before I start? I can hear background.
Absa has her cloud, etc., right? These characters are really powerful and notable edgeguard tools. And what does Forsberg have, right? He really only shines around this area. This area is where Forsberg wants his opponent, because here,
Tom, naendelea
down
mazee jo.
there, is going to kill at like 50 or 60. And that sounds extremely good, and it is really good. This is one of the strongest parts about Forsberg. If I was to say, you want like
If no other person wishes to interrupt me, I'll be getting on with it. So in favor of time. So for our group, we were focusing on the stalemate between the Senate and the National Assembly, and the process that is followed in trying to solve that stalemate. A stalemate is a kind of a situation where it seems impossible to move away from. Both parties want to win in the scenario, so it's like a deadlock per se. Just as you see in the picture, you see in the tug of war when it starts, there's usually a deadlock. That was for visual purposes of understanding what a stalemate is. So right away we'll get into it. The first slide.
To get the back air, it's going to put you back in the same scenario, but now we're going to synthesize it. So once every 5 years, the Senate, by resolution, determines the basis for allocating revenue collected among the counties to allocate within the county level of government. So once enacted, the formula is used as a guide passage of the county allocation of revenue bill, the primary legal tool for the release of money to counties from the consolidated account. So let me just go through a short process of how the revenue allocation bill is done normally. So, okay, when the Senate is making the bill, they should take into criteria Article 203 of the Constitution, which is the Equitable Share and Other Financial Laws Act, which is the criteria used for dividing up the national revenue, as under Article 202, which is basically the same thing. It's the Article 202 is the equitable sharing of national revenue, which ensures that revenue raised nationally should be shared equitably. So they should take into criteria the Article 203 recommendations from the Commission of Revenue Allocation. They should also, if necessary, county governors, the cabinet secretary responsible for finance, and they should invite the public or professional bodies to make submissions on the matter. So within 10 days after the Senate adopts the resolution under Clause 1, the Speaker of the Senate refers the resolution to the Speaker of the National Assembly. And now at this point, within 60 days, the National Assembly is required to approve through vote and be able to decide if they're going to make amendments on the proposed bill. So if the National Assembly does not vote within 60 days, the resolution is regarded to have been approved without the National Assembly making amendments. And if there are issues with the bill, this is where the mediation committee comes in. So
in the recent past, the Senate has 7 plenary sessions, which has failed, which has failed to agree on an agreed bill from the Commission of Revenue Authority. And this stalemate, if prolonged, it causes harm to the individual counties, since money is not just can affect, it can plunge countries into financial crisis, since there is no cash flow to pay. Okay, so next we're going to have this.
But the problem with this, as all the forest burn kill moves basically.
So the stalemate, as mentioned earlier, it's a situation in which further action by opposing or competing parties seems impossible. In August 2019, it was there between the Senate and National Assembly over the share of revenue to be allocated to the devolved units. At the center of that stalemate was the division of revenue bill in 2019. Then the National Assembly proposed that developed unit to be allocated Kenya shilling 310 billion, which was 29.8% as equitable share of total revenue, where the Senate and the Commission on Revenue Allocation proposed 335 billion Kenya shillings as 32.3%. It was due to the use of different formula in computing the equitable share of revenue.
Won't kill at 130. Yeah, and she's floating.
Next.
It won't kill at 130. Won't kill at 140 on the platform. Won't kill at 150. Won't kill at 160.
So I hope you can be able to hear me.
Right. Finally kills at 170 to live force burns down.
Yeah, we can.
Tap to DI.
I'll be taking.
So you will never die.
So now the role coming up with the mechanism of the sharing of the revenue among the counties is upon the CRA, which tables are proposals to the Senate. Then the Senate, the role of approving the mechanism is given to the Senate. Currently, as different formulas that are used to be proposed, used for a period of maximum of 5 years. The first two formulas that were reviewed after 3 years each, there was an issue that was missing in the debate. So one of these issues was the Senate had done very little in being able to help the public to understand the CRA table before them for the consideration. So the proposed system for the 4 main sections, based on the different parameters. First of them is that they are more different related to the service, such as the health and the agriculture sector. The second parameter was to address the marginalization, such as poverty and the access to roads, the health facilities. The third section was meant to incentive the counties to work hard in the raising of their local revenues. So for that, lastly, there was a section that was meant to encourage the prudence use of developed resources. There was some parameters such as the additional option from the general generators and the adherence to the threshold for the allocation of the development expenditure. These formulas most closely were used to define the funds flow function, and the most important to give the public demand on the counties should spend, how the counties should spend their resources well. So according to that, you can be able to see that there was some difference in the values that were there. So the CRA used based of equitable shares of the 314 billion contained in the DORA, that is as 2018, whereas the National Treasury used a base of 4.94 billion. that was contained in the so yeah, you can move to the next slide.
The second reason for the disparity was because they're using a different adjustment factor. CRA was using the base. The base is 314 billion. So with this calculation, the adjustable equitable share would be 21 billion, raising the total amount to 335 billion. However, the National Treasury declared that it will only allow a transfer at maximum of 316 billion, which would still result in a deficit of around 19 billion. And this is part of the reason why there's a deadlock. Tono will continue on to the resolution.
A lot of people don't know that and they just wait it out. If you have Sylvanos or Absa, then you just don't really care
Now,
about
now that you have the background info,
can be swatted by Sylvanos Fair or hit by Absa Cloud, so they really don't even care about that, right? And the thing
okay,
about
sorry, a bit.
I thought you're the one making noise. There's someone whose background is making noise. Continue.
Okay, now that you have the background information on the reason for the stalemate and the details, we will now go to how they actually went about resolving this stalemate. Let's first see what they actually did on the ground before we actually visit the constitution to see whether they actually followed the law or they went against it. So a mediation committee was formed for disagreement, but on the first attempt, they failed to resolve the issue. The mediation committee is usually formed by the Speaker of both houses, the Senate and the National Assembly, and they pick members of equal proportions. On seeing this, the Senate quickly moved to the Supreme Court to file a petition on this bill and seek an advisory opinion on the issue, because this bill, Division of Revenue, you can term it as a sort of a critical bill or a special bill, and at the same time it is also a money bill because it is covered under Article 114 of the Constitution, number 3, clause C, and receipt or issue of public funds. So this was a bill that cannot just be defeated just like that. Because it will be holding funds that are necessary to go into the counties for the country to function. Otherwise, the country will collapse financially. So, on listening to the case, Chief Justice Maraga instructed for the use of mediation once again, and that they resolve it in 2 weeks before the court can give its advisory opinion. They went about again for another round of mediation, and the total length for the stalemate was about 5 weeks from the time it began, and it was finally resolved when both houses actually reached a consensus that saw counties being allocated 316.5 billion Kenya shillings, which was about 30.5% of the total revenue. Yeah, that's about the resolution. Now we'll actually go and see what the Constitution had to usually says, and if they actually follow the Constitution.
2 hours. I'm gonna call it here. I've talked about why I think his intro.
Omoni tawachapa na busara, niko na class na mnanipigia kelele. Na kuchapa wewe kwanza, jelo mkubwa.
According to the Tara, it's me, man. Me ndo nafaa present slide 7.
It's supposed to be Owiti, but Owiti be a bit sharp. We are going against time.
Yeah, so what does the Constitution say? The Constitution says, with reference to Article 112 under Chapter 8 of the Constitution, if one house passes an ordinary bill concerning counties, and then the second house rejects the bill, it will be referred to a mediation committee, or they will have to pass it in some sort of an amended form, and also it might be passed back to the original house for consideration. So if a bill is referred to a mediation committee, the Speaker of both houses shall appoint a mediation committee consisting of equal numbers of members of each house to attempt to develop a version of the bill that that both houses will pass. So the mediation committee will have to agree on a version of the bill. Each house shall vote to either approve or reject that version of the bill. So in the event that both houses approve the version of the bill proposed by the mediation committee, the Speaker of the National Assembly shall refer the bill to the President within 7 days for the presidential assent, because he's the one who has the final say. So if the mediation committee fails to agree on a version of the bill within 30 days, or if a version proposed by the committee is rejected by either house, so that's how you know that a bill has been defeated. Yeah. So I think the next person can explain the diagram.
The next page, I believe you can hear me clearly. So Aguchi has just mentioned something about the final say. It's a very contentious issue in which situation. This diagram shows the 1, 2, 3, 4, 5 bodies or parties that are directly involved in playing a decisive role in the revenue sharing. So we have the CRA, which is the Commission of Revenue Allocation. We have the Senate, the National Assembly, the National Treasury, and then the Parliament. So the CRA basically just makes recommendations concerning the basis for equitable sharing of the government revenue. And then the Senate safeguards the interests of the county government in determining the allocation of the national revenue among the counties. The National Assembly represents the people of the constituencies, and then the people that and the people that have special interests. The National Treasury prepares the annual division of the revenue bill and the county allocation of the revenue bill, and then it takes into consideration the recommendations of the Commission of Revenue Allocation, which is the CRA, and the Intergovernmental Budget and Economic Council. Then the Parliament, which consists of both the Senate and the National Assembly, after not less than 30 days of the introduction of the bill, considers approving them with or without amendments. Go to the next page. Mediation. I think Awiti and Tumna have both explained mediation very well. So according to the constitution, the stalemate is resolved by forming a mediation committee, which consists of members from both parties. And then the aim of the mediation committee is to attempt to develop a version of the bill that will please both houses and therefore will be passed. Upon the completion of the process, it sends a final version to both houses for an up or a down vote. If it's upvoted, it passes. If not, it does not pass.
Okay, 3 more minutes. 3 more minutes, kindly. Wrap up.
Next slide. So, just to finish up what Tara was explaining, within 30 days, the committee is required to. Okay, the committee knows whether the proposed version that they gave to the House is either accepted or rejected. And if it is approved, the version of the bill is then proposed by the mediation committee, is handed over to the Speaker of the National Assembly, and later on given to the President for an assent. So that's just the final process.
The main true antagonist of the series, but also makes Homelander look like a simple spoiled brat with superpowers. This video will go over some major spoilers from the Boys comic series.
Who is taking over?
Yeah, so for the continuation, I feel like it's a repetition of what I had covered earlier, so it's pretty much the same. Come again?
Can you go to the final slide?
Yeah, this was the
This is
final slide.
This is the final
We
slide.
are finished with our presentation.
Sawa. Asante group number 2. Now, I want all of you to send me your group assignments. Please send me by email just now, because I'm going to speak on this. I'm going to do it. So please send me, clarify that you're sending from either BTC or ICS. You say you are BTC group 14, you are BTC group 13, you are ICS group 10. send all your slides today. If I don't receive your slides today, unfortunately, your assignment remains incomplete. And despite the hard work you put in, you'll still have, I will not be able to give you your marks. So make sure you email me your presentation. Thank you so much. I know we have even gone extra time, but I'm happy everyone has had a chance to present instead of going back to where there are those who have not presented. So at least everyone has presented. For those who have had presented earlier and they have hung in there, I hope there's something you have learned. Okay? I know there are many questions. I will not pretend to address the questions now. Please write those questions down. You can send me an email or you can ask them in the next class. So this marks the end of our this session for today. I will hang in here for anyone who has an urgent question, especially the group who I told to redo their work. The rest of you can leave. Thank you very much, please. Thank you. And I'm sorry for the inconvenience caused